Good morning, everyone. We have 6 cases on today's oral argument calendar, and we'll begin with appeals numbers 23-2394 and 23-2541, the United States versus Derek Clayborn. And Ms. Sostek, good morning. Nice to see you. Whenever you're ready.
Good morning. May it please the court. My name is Erin Sostock. I'm here on behalf of defendant appellant Derek Clayborn. The instant case is a perfect example of a situation where the mere presence of firearms at the scene of a crime is insufficient to establish that the firearm was possessed in furtherance of drug trafficking. In this case, the only contested issues on appeal and in the lower trial court were whether or not the drugs that were found, that the firearms that were found in Mr. Clayborn's apartment were related to the actual trafficking of drugs.
Ms. Sostek, before you go too far, can I clarify something, please? Mm-hmm. Your client has filed a notice of appeal in 2 cases. It seems to me that there's nothing at issue in the case that was before Judge Wood, the 18 CR 797 case, that it's only in the other case.
That's correct. Okay. Yes. Yeah. The only issues that we raised on appeal were related to the second case.
Okay. Thank you.
With regards to the first case, Mr. Clayborn actually entered a guilty plea, and for 2 counts in the second case, Mr. Clayborn also entered a guilty plea, admitting that he possessed the weapons and that he possessed the drugs with the intent to distribute them. Mm. However, the government did not meet its burden to prove that the weapons that were found in Mr. Clayborn's apartment at the time the arrest warrant was executed were actually directly related to a drug trafficking crime.
So I think you have, just in the interest of time, I think you have two facts that you got to grapple with on his behalf. First, at the time that the law enforcement team entered the apartment, he was literally in the process of preparing for packaging piles of heroin, 8 or 10 piles of heroin, correct?
Correct.
Okay. The other difficulty that he presents for you is the guns, plural, right, were found in a backpack with a whole bunch of cash.
Correct, yes.
In the master bedroom closet. And so seeing a connection between the guns and the drugs in light of those 2 facts, among others, is not that difficult, at least from the standpoint of the standard of review under which we're operating.
So the facts that you were just drawing attention to, the fact that he was sitting there with the drugs in front of him and with the intent to package them or whatever, that goes to the distribution, the intent to distribute that he pled guilty to already. Here, the problem is that the actual guns that were found in the master bedroom closet, they were up on a shelf, they were in a bag that I believe was closed.
Did the bag also have $30,000 in cash?
It did, yes.
That's kind of weird, isn't it?
Well, it actually also had some medication in there as well, and it looked...
But why does that matter if there's $31,000 in cash?
Maybe he's selling medication.
In an apartment where he is clearly distributing heroin or putting heroin together. Why does it matter that this backpack might have other things besides drug proceeds in it?
So there were prescription drugs in there. One of them was an inhaler the drugs appeared to be for personal use, the medication in the bag. And so what was argued in the trial court was that this could easily be a go bag for someone who, might feel they need to leave their apartment quickly. They have cash.
It's possible. I mean, look, you're doing the best you can on a hard set of facts. It's possible. But you got to grapple with the standard of review, and that is that no rational juror, could have reached a conclusion on this evidence other than the one that you're urging. That's tough.
It's absolutely a very tough standard on review. However, I will just go back to the mere presence argument. So far, all we've talked about was the fact that the guns were actually there and there was drug distribution going on. There needs to be something more than just the fact that the drug distribution and the guns were both in the apartment at the same time. And what is often argued is that the guns are being used to protect the drug business and the drug dealing business, whereas here the guns were totally on the opposite side of the apartment while Mr. Clayborn was allegedly packaging his drugs. So he did not
The
have those
case law
guns
doesn't
handy.
require them to be in the same room. The case law requires them to be easily accessible.
Correct. And I would
The apartment is not that big, and you could get to the master bedroom pretty quickly.
It was on the other side of the apartment, like the complete other side of the apartment, in a closet, inside the master bedroom, up on a shelf, inside a bag that was zippered closed.
With drug proceeds.
Yes, with drug proceeds. Well, no, I will not. I'm not going to. There was
Given
actually
the
no
standard
evidence.
of
$31,000 of cash.
Yeah.
There was a lot of cash, but I will just note for the record that the government did not present any evidence that money in particular was drug
There's
proceeds.
close to $100,000 in cash in the apartment in total, and the defendant was in the process of packaging heroin when they got there. Given the standard of review, that's a pretty steep hill to argue.
It is a steep hill to argue. However, I will say that what the government has proved is that that guns are usually used as protection. However, they did not prove that Mr. Clayborn's guns in particular, because of how far they were away from him while he was packaging the drugs, they didn't show that there hadn't been any drug deals in the apartment whatsoever. So the government also did not show that Mr. Clayborn had in the past used these guns for protection in any way.
Yeah, what concerns me about your argument is you're close to arguing that direct evidence is needed. So, one, a circumstance where the gun is in his waistband, our laws never required that. Or two, that the defendant makes a post-arrest statement saying, I possess the gun to protect my drug stash and my cash. And we've never required a post-arrest statement from a defendant either.
I agree that it does not require direct evidence. However, I would say that looking at the factors that this court looks at, which is, whether or not the weapon is easily accessible, the type of the weapon, whether it was stolen, the status of the possession, and whether it was loaded or not, those factors in this case show that all we have here is that the guns were in a separate room to where the drugs were. And yes, there was money, but there was never any evidence.
Are you saying that the gun has to be used in connection with the actual distribution of the drugs as opposed to protecting the drug proceeds?
No, but I'm saying that there needs to be some evidence that the guns were being used to protect the drug proceeds.
And you don't think
apart from
any
just-
reasonable juror could draw that inference based on the fact that the two loaded handguns in the same apartment were in a backpack with over $31,000?
I think that
That no reasonable juror could draw that inference.
Well, I will note that this was a bench trial as well, and so we're actually reviewing the trial court
The
did have an
standard of
opinion.
review is the same.
I would say that I don't think that it's reasonable to draw that for a juror to draw that inference in this case, because this court requires there to be more than mere presence in the vicinity of the offense. And here I believe that all we have is the mere presence. And I will just conclude there and save the rest of my time for rebuttal.
Yeah, of course. Very well. We'll hear from the government.
Good morning. Jared Jodry here on behalf of the United States. The district court correctly concluded that the evidence proved beyond a reasonable doubt that Derek Clayborn possessed a firearm in furtherance of a drug trafficking crime. The defendant is here challenging the sufficiency of that evidence, but as this court has already observed, that the standard of review here is deferential. Right? The defendant needs to establish, carrying a heavy, as this court has described it, nearly insurmountable burden, that no rational trier of fact, looking at the evidence in a light most favorable to the government, would have found him guilty. And they just haven't proven that. They haven't met that high standard here. Right? The evidence.
Did Agent Karzeski here testify as an expert?
He did.
Okay.
And what he put forward was the government's theory of what these guns, the 3 loaded firearms in the apartment, the same apartment where he is in the process of packaging over 1 kilogram of fentanyl-laced heroin at 5 in the morning, right down the hall. with over $100,000 in cash, a bag with 2 loaded firearms containing over $30,000 in cash. Derek Clayborn was a felon. He was not allowed to have any guns, let alone 3 loaded firearms in his apartment. The court made the rational, reasonable inferences, applying common sense, considering the case law, the factors that this court has highlighted, and came to the conclusion that he was guilty. And the evidence supported that conclusion.
Mr. Jodry, is when we talk about this apartment, we're not talking about an apartment that runs the entire floor of a building. It's a very typical 2-bedroom apartment.
That's correct.
And when I look at the floor plan, he was packaging the heroin in there, or cooking the heroin, whatever he was doing, in the laundry room, right?
That's correct. You walk in the apartment, the laundry room is off to the sides where he was packaging all the heroin. He had the scales, he had the bags, he had the little baggies, and
the backpack's in the master bedroom closet.
Right.
Any doubt that the master bedroom belonged to him?
Nope, was not contested.
And the only 2 residents in the apartment, if memory serves, well, there was a child that was sleeping in the apartment, unfortunately, right?
That's correct.
And then he was there, but no other occupants, right?
That's correct. His, I believe, fiance at the time was out in Las Vegas, but he agreed and stipulated to all the evidence establishing that that was, in fact, his apartment, that was his bedroom. Between the laundry room where he was packaging the heroin and the bedroom was just the living room area. This was just a 2-bedroom apartment.
So you walk through the living room, you walk into the master bedroom. There's
It's right there.
a million apartments like this in Chicago.
Correct. If there are no further questions, we ask that the court affirm the district court's verdict.
Okay, very well, thank you.
Thank you.
So, Stock, you had some time left on rebuttal. You're welcome to use it.
Recognizing that there is a high burden as far as the standard of review in this case, I will just note again that we do need here is more than just the presence of these guns in the apartment. And yes, it was a small apartment, but that doesn't, Mr. Clayborn still had to go to the complete other end of the apartment into a closet and open a bag to get out these firearms if he wanted to use them as protection. And when the police went and executed the warrant, he was there in the middle of packaging guns. He made no effort, packaging drugs, sorry. He made no effort to reach for those guns or attempt to get those guns, even though the apartment had been breached. Additionally, I will also note that there just was no previous evidence that Mr. Clayborn had used that apartment for drug dealing at all. So there's no evidence in the record that the guns had been used for protection in drug dealing. The only evidence is the fact that they were there in the bag with some money, a lot of money. And so I would argue that this court does need to find that there is a link between the drug trafficking and the actual firearms that were found in the apartment, and not just the fact that most drug dealers tend to use firearms for protection. There needs to be a connection between Mr. Clayborn's drug dealing and these firearms, and I do not believe the government met its burden on that respect. Thank you.
Okay, thanks to you, Ms. Sostock. I see here you accepted an appointment by the court to represent Mr. Clayborn, correct?
Correct.
We
Yes.
very much appreciate that, your service to him and to the court. Mr. Jodry, thanks to you. Nice to see Mr. Fullerton as well. We'll take the appeal under advisement, and we'll proceed to our second argument.
Thank you.
Our second appeal of the morning is in number 23-1725, Robert Decker versus Catherine Seierveld and others. Yeah, Mr. Bruton, good morning. Whenever you're ready.
Good morning. May it please the court. Hunter Bruton on behalf of plaintiff appellant Mr. Decker, along with Eric Zimmerman at counsel's table. I would like to reserve 5 minutes for rebuttal. Mr. Decker is asking for narrow relief to which he is constitutionally entitled. access to freely downloadable PDFs of the Federal Register. Defendants already provide electronic access to PDFs of part of the Federal Register, and defendants do not deny that they could download PDFs of the full Federal Register with only 3 clicks for free. The question is whether defendants can refuse to make those 3 clicks, and they cannot. Mr. Decker has a First Amendment right to read and comment on administrative rulemaking. Defendants are infringing that right by denying Mr. Decker access to the full Federal Register, and defendants lack a valid justification for that infringement.
Mr. Bruton, are your claims under the APA, or are they straight First Amendment claims?
So it is a First Amendment claim brought pursuant to the APA, so under the APA.
So the APA framework applies, you agree?
Yes, Your Honor.
Okay.
Under the APA, if an action is unlawful under the Constitution as a matter of law, then reversal is warranted, and the standard of review here is de novo on summary judgment. In that regard, the government put on no actual evidence of cost below. I would point this court to its decision last year in Ahmad. We have cautioned prison officials that they cannot rely on the mere incantation of a penal interest, but must come forward with record evidence to substantiate the interest is truly at risk.
What about their affidavit, where they state in paragraph 7 that it would be impractical, highly burdensome, and far exceed the BOP's limited budget and staffing resources?
So that is similar to the incantation of security interest in Ahmad, and in other cases cited in our briefs, it's been held that those kind of affidavits are rote assertions, so they need some actual evidence of cost.
But in the other cases you're relying on, the plaintiff had come forward with evidence that called that into question.
So in Ahmad and Jones versus Van Lannen, this court also made clear that a pro se prisoner litigant's verified complaint and briefs can serve as evidence of the summary judgment standard. Here, we are relying on Mr. Decker's de minimis alternative of providing the Federal Register electronically. He provided all the evidence he could on that. He doesn't have access to the internet, so he can provide a more developed showing, which is also another reason why he needed counsel below. Going back to paragraph 7, again, part of the Turner analysis is comparing the de minimis alternative to a substitute that the defendants put forward. And here in that same paragraph, they say it would be impractical, highly burdensome, and far exceed the limited budget and staffing resources to distribute paper copies every day.
Can I ask you a question, just my ignorance of the Federal Register? The way I understand the way the Federal Register works is there may be new things published in the Federal Register every day, but the period in which they're published is longer than 1 day. Okay? So I think what your client is asking is not that the BOP download a new version of the Federal Register every day. They can probably do it once every 10 days, let's say, so long as they capture the notice period, whatever the notice period is, 14 days, 30 days, whatever. It may be that they can download it. I mean, these facts would have to be developed in the district court if we were to remand, but they may be able to download it once every 30 days, let's say, and that may put more of a burden on your client. You know, it's easier to read the newspaper every day than it is to read the newspaper once every 30 days, right? But it may be that he could review it once every 30 days. It'd be harder for him, but he's not asking for it every day is the way I understand it.
That's right. And on appeal, we've also said, once a week might suffice. I think Your Honor's hit it on the head. So comment periods will be 30 days at least, unless regulation isn't required to undergo notice and comment. So as long as Mr. Decker is obtaining some version of the PDF of the Federal Register in a way that would allow him to comment on rules, that would be sufficient injunctive relief. And it may be, so there's some regulations also that'll have 180-day periods or even longer. And so again, the question is just whether Mr. Decker can get these regulations in time to comment on them, like the FCC regulations on prison calls, HUD housing, things that Mr. Decker is worried about both while he's in prison and when he gets out.
Was there any development in the district court regarding the manner in which and the time it takes for the BOP to go through and sort of splice out regulations which they provide to prisoners versus the other? I mean, it just seems, and I'm asking, it just seems to me like it'd be easier to just publish the whole doggone thing than to parse out here's what may apply and here's what may not apply.
Agreed, Your Honor, and we don't have evidence, but we think it stands to reason with common sense that it may actually save the BOP time and money if they're not having to parse through BOP regulations. And we also note, as we did in a footnote in the opening brief, that the BOP actually missed 3 of its own regulations in the timeline that it says. So, and again, the only evidence we have is the Qureshi declaration and then her supervisor's declaration, who was, I guess, took over the job. We don't know exactly how it works. It's framed in the passive voice as these things are posted to the electronic bulletin board. But, and perhaps the government can shed more light on this, but I think there's probably 2 realities here. Either one, Ms. Qureshi or someone who would be in her office now in DC uploads these PDFs to a terminal, and that terminal pushes out to prisons. Or there could be a prison staff official at each federal correctional institute that takes an email from Ms. Qureshi or someone similar and then posts it on the electronic bulletin board. I think it's important to note that, again, going back to the substitute they're comparing it to, the reasonable alternative they say is mail. And we've explained in our opening brief with record sites why mail is not a reasonable alternative for Mr. Decker. But I think,
Burton, can I, sorry to interrupt you. Go ahead and finish your thought.
Oh, no, excuse me, Your Honor. I was just going to say, you have to compare how long it would take a prison official to process many, many mailed copies of the Federal Register to somebody downloading a PDF with 3 clicks and posting it on the electronic bulletin board.
So I've got a broader question I'll come to in a second. But on that point, I noticed in preparing for argument that there are many states, at least the states in our circuit, that maintain state registries, the state analog. And I looked at Indiana in particular, just randomly pulled it up, and either 3 or 4 mouse clicks, you can get the Indiana one in a PDF too. So the point I'm making is to ask you about the limiting principle here. That it just seems that the next case is about the Indiana registry, and then we're on to the Alaska registry, and et cetera, all kinds of publicly available information that a prisoner could allege or advance an interest in as part of vindicating First Amendment rights. Where does this end?
So I think this case provides 2 limiting principles. One is the APA, and 2 is a time-tested Turner test. So taking your hypothetical, Your Honor, I don't believe a state APA would allow a suit against a federal official. Here we have the APA providing the waiver of sovereign immunity and the cause of action for unconstitutional or arbitrary and capricious actions.
Right, but couldn't you just bring your 1983 action and seek declaratory relief or something?
So if you brought an ex parte Young suit or an injunctive suit under
Right.
1983, right? So Turner will provide the backstop there. And again, I think the important...
Why there but not here?
So to be clear, prisoners have a First Amendment right to read and comment on other things too, things in the congressional record, other matters of public importance. This court, in many cases, I'll point you to Littler and a few of the other mail cases in the Seventh Circuit, the court's been able to use Turner in a practical way to say if there's some evidence of cost or if there's a security justification. I think security justification is going to come out in a lot of these cases. So when you're dealing with non-government materials or newspapers, this court has parsed out whether or not there's a security.
So in tomorrow's, if you're right, in tomorrow's case, if an inmate says, I'm going to be released in a year or 2 and I'm planning on living in Indiana, and my interest is being a responsible citizen in Indiana, and therefore I want to follow the affairs of the state as posted in the Indiana registry. And if Robert Decker was successful in getting the federal registry made available, I should surely be successful in getting the Indiana registry. After all, it takes 3 mouse clicks.
I think on the facts of that case, and if the prison has no other evidence on cost or security, then the state registry might be provided. But it also matters how the electronic law library might work at that individual facility if we're talking about a state facility. And again, this is not on the record, but some states also have access to internet. Some states also give prisoners iPads.
So your point
Most
is...
federal prisons do not do that.
Correct.
They don't have internet access.
I don't believe any federal prison has internet access
I
provided
don't
to
think
inmates.
it does either, or give them iPads, other than maybe some computer facility to review discovery materials, but not what you're talking about.
Like a terminal, yes, Your Honor.
So your point, just take them one at a time. Turner supplies the framework. That's why the Supreme Court put it in place, and you just adjudicate them as they arise.
That's correct. And again, there'll be questions about the cause of action against any state, local, federal official. It'll still have to pass all those things. The PLRA is also a backstop, so prisons have grievance procedures set up, and they have to exhaust the grievance procedure. So if a prisoner comes and says, hey, you can download this Indiana State Registry with 3 clicks, this is how long it'll take, would you provide it to me? A lot of times reasonable prison officials are going to say, yeah, we'd rather do that than litigate a federal case for 3 years.
Okay, here's my other question. It's a broader question. I have some concerns about whether your client has standing. Okay, you've done a terrific job in your briefs representing him. There's no question about it. But you are making points that, to my eye, seem divorced from the way the case was litigated before you and your colleagues, accepted the appointment. And what I mean by that is to get right to it, is this. When I read Mr. Decker's complaint and I read what he submitted in opposition to summary judgment, I have Lujan, Clapper-like concerns about whether there is actual or imminent injury and what he has said to satisfy that.
So I'll answer that question and reserve the remainder if I may.
We'll give you rebuttal time. Don't worry about that.
So on the standing question, again, I understand it's subject matter jurisdiction. The court reaches it even though the government doesn't contest it. So we're not backing away from the difference from this and access to court claims. Mr. Decker has a freestanding right to comment on the Federal Register, and he can't be more particular about the regulations he wants to comment on because he doesn't know what the regulations are since he doesn't receive the Federal Register. So Article 3 just requires traceability.
Keep going.
So Article 3 requires traceability to the injury. The injury is restricted access to non-BOP materials in the Federal Register.
Okay, in fairness though, he's pretty skimpy on what he says about that. When I read all the summary judgment briefing last night, and he is focused in the main on BOP related. Now BOP is a big umbrella. He's focused on the First Step Act. He's focused on the affairs of the U.S. Sentencing Commission and amendments to that. But he doesn't anywhere, for example, say, I'm keenly interested in following the affairs of the EPA or, the SEC or whatever. There's nothing like that. And I mean, I can see standalone sentences where he says, I have an interest in following the affairs of other departments or agencies. But what I think about the plaintiff in Lujan. You know this case law.
Yes.
I think about the plaintiffs in Clapper. And I think about the justices saying we are serious about subject matter jurisdiction and the injury requirement of standing.
Yes, Your Honor. So
That's not to say he couldn't plead it, and develop it at summary judgment, but I very much wonder whether he's done so here. You have in your appellate brief.
So, agreed, Your Honor, that Mr. Decker could have done a better job on summary judgment, but we maintain that by Mr. Decker saying he wanted the full access to the full Federal Register, he did enough for standing. Now, understandably...
Why is that enough here but not enough in Clapper?
So
you remember Clapper?
Clapper is the Foreign Surveillance Act case,
right. You remember that in the court said there's nothing here about impending injury. If your client, I'll give you rebuttal time. Don't worry about that.
Yeah.
Okay. If your client had said, like you do on appeal, at some point, God willing, I'm going to be released here, and I'm interested in following what's going on in the Department of Veterans Affairs or HUD or whatever, because I'm going to be a responsible citizen when I get out. He might do enough there, but I just don't see it.
So I would also point this court to this case law that says prisoners' complaints and pleadings are construed liberally. I think, to be fair, this issue is a matter of law that's cleanly teed up. If the court has concerns about the pleadings, I think this is also evidence that Mr. Decker should have had counsel below, and on remand, the court can allow for an amendment of a complaint. I think.
So one of the reasons that I think you may have, I think your points are fair about the I don't remember her name. It begins with a G. The affidavit that came in from the BOP.
Qureshi, yes.
Yeah. Okay. It's thin, and you're right to emphasize that. But I wonder whether it's thin in part because Mr. Decker wasn't all that clear about what he wanted. I think in the main he was focused on criminal justice related information. You know, broadly construed, Sentencing Commission, First Step Act, etc.
Right, and I think that alone would be enough, right? Sentencing Commission is a separate agency from the BOP.
And then you just wish the case would have gotten litigated that way, because if he would have said, hey, I'm a federal prisoner and I absolutely have an interest in what the U.S. Sentencing Commission is doing and not doing, and Judge, there's none of this on the bulletin board and there's none of this in the library, that's a serious claim.
So on the record, I will leave the court with SA 284, and I think this is a helpful quote from Mr. Decker. Mr. Decker has shown and disputed the defendant's theory that I have not demonstrated the failure to provide a complete copy of the Federal Register in real time based on resources and budgetary concerns is in fact arbitrary and capricious.
What are you reading from?
This is SA 284. I believe this is Mr. Decker's summary judgment, or opposition to summary judgment.
All right.
And this is the not the first paragraph, not a full paragraph at the top. This SA 284.
All right.
And again, I agree with the court that the case could have been litigated better. We would submit that that's more evidence, as this court's recognized in appointing counsel twice, that Mr. Decker would have been better off with counsel.
Okay, I'm going to give you the
Can I ask a question?
Please, yeah.
And as Judge Scudder said, he'll give you additional
Of
time
course.
for rebuttal. I want to make sure I understand what you were saying about the limiting principle, because I have some concerns of, okay, if he's entitled to this, why couldn't an inmate come in and say they're entitled to a whole host of things? Was your response to Judge Scudder's question that this would only pertain to government materials, it would not pertain to non-government materials? So if he comes in and says, I'm entitled to the New York Times online and I don't have it, I have a right to read what's going on and a right to know what's going on in current events and politics, would the same argument apply to that?
Well, I think this court in Lindell and Jackson versus Frank already reached that exact hypothetical and said prisons can ban newspapers for security interests, that they don't want the guards going through that. I think, to Your Honor's bigger point, as with any other First Amendment inquiry, the higher the level of matter of public importance, the stronger the claim is. I will say one thing briefly about the APA. The APA already provides the way to exercise the First Amendment constitutional rights. Interested persons are provided the Federal Register, and they can comment on regulations they're interested in. That is a limiting principle in itself, and there is no New York Times APA. There are plenty of other cases. Lindell and Jackson versus Frank are two very good examples. Littler is another one where district courts are, as Your Honor is aware, well equipped to kind of do these Turner inquiries and take care of them at the screening stage at 12b6 and at summary judgment. I don't think this case will be a sea change.
So your argument is not going beyond the register here, the Federal Register?
That is correct. Mr. Decker in this appeal is seeking access to the Federal Register, and he's entitled to that under the APA and the First Amendment.
Okay.
Thank you, Your Honor.
Very well. Yep, of course, Mr. Bruton. Let's hear from Ms. Tan, and we'll come back to you for that rebuttal.
Good morning, Your Honors, and may it please the Court. Caroline Tan for the government. The very nature of incarceration imposes limitations on the ability to engage in quintessential First Amendment activities, like going to a town hall or attending a protest. These incidental consequences of incarceration have never been understood to violate the First Amendment. And it no more violates the First Amendment than Mr. Decker's incarceration may pose practical challenges to reading the Federal Register and submitting comments. Unlike every prior prisoner free speech case to come before this court, there is no prohibition here on what Mr. Decker wishes to do. The fact that he cannot do so as easily as he would like does not create a constitutional problem for the Bureau of Prisons to solve, and for good reason. As Your Honors have already noted, Mr. Decker asks for the Federal Register today, but his theory would equally establish a constitutional obligation to provide other materials tomorrow, such as proposed bills in Congress so that he can submit comments to his congressman, the state equivalent of the Federal Register for each of the 50 states, or all state laws and court rules, which Mr. Decker is already seeking in a separate lawsuit. there's simply no limiting principle to Mr. Decker's theory.
Ms. Tan, I think this case would be a lot easier had the affidavit said what you just said.
Yes, Your Honor.
This affidavit is thin, very thin, and it is subject to all the criticism that Mr. Decker, with the help of Mr. Bruton, has leveled against it. It just very, very generically talks about resource limitations, burdens, etc. It just doesn't tell us much.
Your Honor, I think that the affidavit is sufficient in light of the Turner standard. I mean, I will note that the declaration itself states in footnote 3 that BOP doesn't regularly post these kinds of these kinds of materials at the moment because BOP rules and regulations don't come out every single day. In fact, from 2016 to 2018, there were no BOP proposed regulations that were coming down the pipe. So what we are talking about, and what is supported in the record, is that we would go from a system where BOP posts something a couple of times a year, a few times a year at most, to something where BOP would now be required to post every edition of the Federal Register, whether on a weekly basis, daily basis, etc.
Why isn't it just 3 clicks that could easily be posted on the bulletin board?
As we note in our brief, Your Honor, 3 clicks is what Mr. Decker has asserted to upload one particular Federal Register material. But when you're talking about the course of a year, every single day, whether it's that 3 clicks quickly becomes thousands of clicks.
150 clicks.
150 clicks. And even if that takes 10 minutes a day, which is just, some sort of small number, that amounts to 2,600 minutes in a year, which is over 40 hours in a given year. That's an entire work week, and it's not de minimis just because that work week amount of material is spread out over the course of a year. And this court has already recognized a distinction between one-time requests and general requests, as it did in Lemon. There's a difference when you're asking BOP to do something once versus when you're imposing a recurring obligation that is not going to end. And as we have noted, this case might just be about the Federal Register, but there's no limiting principle to this theory. So what we're really talking about at the other end.
I'm interested in that. What are we supposed to do with that? Ignore Turner and say because there's no limiting principle, we're not going to apply Turner based on the facts that we have before us? We're just going to presume that in the future, these parade of horribles, and because of this parade of horribles, we affirm the district court.
No, Your Honor. We are not asking you to ignore Turner. We think that we easily meet the standard under Turner. Based on the record itself, we have already told you that BOP doesn't regularly upload this material. So we would go from a world where we upload at most a couple of documents in a year to every set of the Federal Register from now until the end of time. That's supported in the record. That's in the declaration itself. And that is not a de minimis burden.
Is that paragraph 7 in footnote 3 you're relying on?
That's right, on page 208 of the supplemental appendix. And
Do you agree that the case, I'm asking this as a broader question, Mr. Bruton may have a thought on it too. It seems to me that the case has to be analyzed within the Turner framework, as Judge Kirsch. You agree with that?
we think Turner applies, Your Honor, but we think that this case is significantly easier than every single Turner case to come before this court because, as we know in our brief, there is no restriction here. Mr. Decker is allowed to read the Federal Register.
Okay, the reason I'm asking that is in the district court in your briefing, these are my words, not the government's words in the brief, you seem to suggest that there's like something you might think of is like a Turner step 0. In other words, that the First Amendment right to petition government is so weak for somebody that is incarcerated and is trying to petition through access to non-BOP related Federal Register materials that you really don't even need to get into Turner. That's a position the government took in the district court. That sounds to me, my words, like a Turner step 0. Is there such a thing?
We think it can be thought of as Turner Step 0. It can be also thought of as being part of the Turner framework.
Well, hold on. My question is there such a thing as Turner Step 0? Or come up with better words to describe that.
Yes, Your Honor, if by Turner Step 0 you mean you're looking at the restriction at issue and the
and not
extent to
even
which that is a
evaluating it
First
under the
Amendment
4
right.
Turner factors. What supports that?
Well, Turner says that an institution is able to impinge on a constitutional right if it meets this particular standard. And so I guess the step zero would be, is there a right that's being impinged in the first place? And I think that
Is there a right that's being infringed, or is there a right?
Well, is there a right in the first instance? Yes. And we think that any right here is incredibly weak. Mr. Decker isn't saying, I need this material to challenge my conviction. I mean, this case is not, even though it sounds a lot like an access to court case, it hasn't been litigated that way. So what he's asking is not even just material in order to challenge his own conviction or sentence. He's asking for something to make some generalized comment on the state of the world and to comment on the full range of federal government activity, which includes things from, as we noted in our brief, notices regarding studies of wild pigs, updated common carrier list, that sort of thing.
Do you have any reaction to my questions about Article 3 standing?
We did not litigate standing in this case, Your Honor. Mr. Decker, as you identified, has not articulated which particular agency material he needs, why he needs it. He's instead asserting a generalized interest in the federal government's activities, which does sound a lot like the standing cases that you have identified. In the district court, all he has really asked for is just the Federal Register, somewhat akin to a newspaper, so he can browse it and see what it is that he wants to comment on, but he hasn't articulated a particular reason.
The only specificity that I see relates to criminal justice matters.
Yes, that's right, Your Honor.
And the Sentencing Commission, and the First Step Act.
Yes, and BOP does provide BOP-related regulations, which should encompass the vast majority of those kinds of interests. It's not in the record, Your Honor, but BOP has worked with the Sentencing Commission to provide Sentencing Commission materials, but that is not in the record. I think that Your Honors highlighted a very good point earlier that this theory, if adopted, would be a significant expansion of the First Amendment right. Again, there is no restriction on what Mr. Decker wants to do. If somebody printed out the PDF of the Federal Register and sent it to him, he would be allowed to read that. And that makes this case very different from every other free speech prisoner case to have come before this court. In Jackson already, this court has upheld an outright ban on one type of content, where the prison's only asserted justification was its resource limitations. This case is significantly easier than Jackson, and so
I don't think Mr. Bruton is questioning that BOP resources is a legitimate reason to look at. He's just questioning that it hasn't been proven here.
Jackson is relevant in as much as that justification was sufficient to uphold an outright ban on that type of content, and our argument here is that justifications should equally be sufficient to uphold something that's not a ban at all. Instead, Mr. Decker...
I think the challenge is to the evidence supporting that assertion.
Again, I guess there are several responses to your question about whether or not BOP has sufficiently articulated its burden. The first, as I noticed, we haven't stated in the record that this would be we'd be going from a situation where we post only a few documents a year to one where you have to post every single edition of the Federal Register. The second is that there is no dispute that this would be a recurring task that would be imposed on the BOP ad infinitum. Mr. Decker has framed this as just 3 clicks, but even accepting his framing, what we're not talking about at the end of the day is 3 clicks over the course of the year. We're talking about 150 clicks or so on. 10 minutes a day amounts to 40 hours in a given work week. That would not be de minimis if that 40 hours was consolidated. The fact that it's spread out over the course of the year doesn't change the ultimate burden on the BOP's resources.
Based on what's in the record, is that something we can acknowledge?
This court has recognized that you can consider whether or not a connection is self-evident. That's actually in Scheimer, which is the case that's in Mr. Decker's brief itself. Part of the reason why the court thought that the evidence was insufficient in Scheimer was that the connection was not otherwise self-evident. The Bureau of Prisons, so that the institution in that case needed to provide a little bit more explanation. But that's not the case here. It is obvious that what we're going from is a world where we don't post all that much to a world where we have to post every edition of the Federal Register. It's reasonable for BOP not to provide this material in its existing law libraries.
10 years ago, you used to provide it in hard copy, right? Or I might be wrong on the time frame, but the Federal Registry was available in hard copy for a while, correct?
Mr. Decker has asserted that, yes, in his filings. I don't know the precise answer to that question.
I just wonder if
But
it
that
would be
is-
better. I wonder if it would be better for the district court to have determined these facts, because I'm not sure that 10 minutes is accurate. It might be 10 seconds. It might. I'm not accusing you of saying. I'm just saying I don't know. I mean, it may be closer to 10 seconds a week than 10 minutes a week, and I have no idea how many employees the BOP has, but it's a lot. You know, and I have no idea how many employees could do something like this. Is it something that can be done from Washington? Is it something that has to be done at every single prison? You know, could one person be assigned this responsibility as part of his or her job? These are things, when considering the resources to BOP, that I would like to know, that we're here in the Court of Appeals just guessing as to these facts. I think, I mean,
That may be the same reason why we're better off with a lawsuit that alleges this stuff, alleges the injury with some particularity. And then the whole thing could get litigated the proper way. It's really that when you look at what's going on appeal, the government submitted a fine brief, Mr. Bruton submitted a great brief, all that. It is very disconnected from what you see in the district court. I mean, you recognize it as the same case, but that is about it.
But, Your Honor, there is no dispute that Mr. Decker is asking for something that would require uploading a daily publication that comes out every day that can be 100 to 500 pages.
Is he asking for daily or just in a timely manner to respond within the
Like-
time period?
He's asking for every issue, which comes out every day. So by daily, I just mean he's asking for the Monday, Tuesday, Wednesday,
None of that's in
Thursday,
front of the
Friday.
district court. It's all in the appellate briefs.
In the district court, he asked for the Federal Register so that he can decide
No, I know,
whether
but
or
he,
not-
yeah, definitely that. But this whole business about, well, let's compromise and let's do it every week or every couple weeks or once a month or something, just to allow him to exercise the right to comment. That's all the fruit of excellent appellate lawyering. That's not what's in front of the district court when the district court is deciding the summary judgment motion.
But this, I guess the legal analysis would not change even if this were to go back on remand, Your Honor, because because again, there is no restriction here. He is permitted, I mean, if he wants to read the Federal Register, he can do that tomorrow. If someone sends it to him, he's allowed to read it. There is no ban on that, and he's allowed to submit comments. And that's a critical point that we wanted to emphasize in our brief, that Mr. Decker is actually permitted to do what it is he says throughout this litigation he has wanted to do. And, you know, inmates regularly submit comments to the BOP in response to BOP proposed regulations. They have this existing system. It is currently working. Nothing is stopping Mr. Decker from doing this. The only thing is that he doesn't think that the BOP's existing law library is good enough, and he wants to seek an injunction to force the BOP to provide the materials that he's asking for. And so it doesn't seem like the legal analysis is going to change at the end of the day. Again, you know, the Supreme Court has, in a number of instances, upheld prison regulations that restrict access to, for example, newspapers and photographs, and there is no constitutional entitlement to this, freestanding constitutional entitlement to this. And even in the context of access to court claims, the Supreme Court has said that there is no right to a law library and that sort of material. So even when you're trying to challenge your own conviction, this was in Lewis, even if you want to challenge your own conviction or sentence, you don't have a right to dictate the contents of the law library, or even you don't even have a right to the law library in the first instance.
Does the record say, if anything, about the availability of materials from the U.S. Sentencing Commission in BOP libraries?
The BOP policy says that it provides U.S. sentencing materials. I can find that page for you, but it is in the program statement, which begins on page 210 of the.
The only reason I'm asking that is the BOP, the Sentencing Commission, is a distinct entity from the Bureau of Prisons. They're not one and the same, correct?
That is correct.
Okay, and so when the United States Sentencing Commission proposes amendments to the sentencing guidelines, are those made available to prisoners?
The record states that U.S. Sentencing Commission materials are available, and this latter part is not in the record, but BOP has worked with the Sentencing Commission to make those proposed regulations available and given inmates an opportunity to comment. That latter part is not in the record, though.
I mean, that was one of his big focuses. His supplemental opposition to summary judgment is an email. He emails the U.S. I mean, he just typed in U.S. Sentencing Commission, so I don't know if the email went anywhere. But the complaint that he was trying to register is that materials from the Sentencing Commission were not available to federal inmates, at least not where he's housed.
Well, that's contradicted by the record, Your Honor, and is simply not true. The record does state that BOP policy says that you need to provide U.S. Sentencing Commission materials in addition to BOP materials, and to my knowledge, that is what BOP is doing.
Anything further you want to add, Ms. Tan?
Unless there are further questions, Your Honor, we urge the court to affirm.
Okay. Mr. Bruton, we'll give you that rebuttal that you asked for.
Thank you, Your Honors. If I may, 2 points, one on record and standing and 2 on the merits record and the mail alternative. So on the record and standing, we explained why Mr. Decker doesn't have to point to specific regulations. We maintain that position, but to the extent, Judge Scudder, you're operating in the framework of Mr. Decker needing to identify other regulations, I'll point you to SA 49, where he challenges in his brief in support of the complaint, or motion to dismiss, I believe, he drug classifications, including the drug classification of LSD. That would be the DEA. I would point you also to SA 31, which is his 4th amended in the operative complaint.
Yeah,
now,
I thought you might mention that. I don't know what he's talking about. I mean,
So-
the drug classification of LSD, what you wonder about is how does that have any personal effect upon him? It's not as if he's going to be able to use LSD while in the BOP.
Well, the APA provides all interested persons an opportunity to comment. He has people on the outside who have access. And the drug, I don't want to get stuck on the drug thing.
I hear you. I don't know what to make of it either.
On SA 31, he mentions drug counseling and mental health. That would be the purview of HHS possibly. Again, drug laws, DEA, and then the U.S. sentencing guidelines. And on the U.S. sentencing guidelines, what the government's pointing to is a 1999 program statement that says the policy is to provide it. But the issue is they don't follow the policies. And they're not contesting that they provided even all BOP regulations. And we can't inject those facts in the appellate posture. If the court thinks those facts are relevant, and the right posture is to remand, appoint counsel, and allow the record to be developed. Briefly on the standing cases, Clapper, the plaintiffs didn't even know they were being affected by the action. Lujan, nobody had plans to go to the park. Here, Mr. Decker has definite plans to read the Federal Register, and BOP stopping him from doing that. Also point the court to FEC versus Akins, 1998 Supreme Court case, denial of information gives rise to standing. And again, if the court has jurisdictional concerns, that can also be addressed on remand.
Mr. Bruton, moving on beyond standing, you've raised a lot of arguments in your brief that were not raised below. Why haven't you waived those?
So Mr. Decker, by bringing the substantive count under the First Amendment and under the APA, did enough for preservation under this court's precedent. The government hasn't claimed waiver or even forfeiture here. Of course, it's a matter of prudence, and this court can deem it. But to the extent the court's going to reach out to contest an issue the government doesn't, I would say liberal pro se litigant pleading, we would ask the court to remand, appoint counsel, and have a fair shake at a case that has merit. And I think that's probably the important thing here too on the mail. So on the mail, if we credit what the government's saying, they're saying if I can get the ACLU to send every prisoner in the United States a copy of the Federal Register, they will process it in a timely manner. They would rather do that than download a PDF with 3 clicks for free. That's absurd. And more importantly, it is a record issue.
Again, the 3 clicks for free is not in the record below. We don't know if. So you're making these new arguments that the district court didn't have the opportunity to address, and I'm not sure why we should be addressing them for the first time on appeal.
So the court is within its authority, obviously, to remand and not enter summary judgment for Mr. Decker. But on the 3 clicks point, Mr. Decker said the Federal Register is available in the internet for free. He doesn't have the internet, so he can't do that. Now, this court can take judicial notice of a website, and the government below submitted screenshots of the Federal Register, which includes the current issue link. Now, I agree.
But there's no internet access at the BOP, so that's not what the standard is. they'd have to put it on the electronic board, and we don't know what that entails because it's not in the record.
Wait, Your Honor, BOP facilities do have internet access. Inmates don't have internet access.
Inmates don't, exactly.
Correct, but that's how the electronic bulletin board comes out. And to the extent there's a factual question about any of these issues, again, the proper posture is to remand for fact-finding on these issues. Mr. Decker can't do this kind of discovery while incarcerated. He himself, as you noted, doesn't have access to internet, so he cannot show or depose Ms. Qureshi and say, does it take you 30 seconds or 10 minutes?
He could have deposed her. There's nothing that would have stopped him from doing that and asking her how long, or asking her about the process.
In his motions for appointment of counsel, Mr. Decker said he was not able to get the discovery he sought. He wasn't able to meet and confer with the United States. That was what you would have done on a Rule 16 or Rule 26 or a settlement conference, which Mr. Decker did point out. We have all those record sites. Again, if there are any record sites the court is interested in, I'm happy to file a 28J or respond to supplemental briefing. If the court has no further questions, we would ask to reverse and remand and enter summary judgment in favor of Mr. Decker. Now, if the court is not going to grant us that relief, we would ask at least that he get a fair shake with counsel below to develop a very limited factual record and have a chance in court. Thank you.
Okay, Mr. Bruton, thanks to you. You accepted this appeal on appointment, correct?
Correct.
We very much appreciate that. You've served Mr. Decker very well, Mr. Zimmerman, thanks to you and your firm. Ms. Tan, as always, thanks to the government. We'll take the appeal under advisement.
Thank you, Your Honor.
That'll take us to our third argument of the morning. It's appeal number 23-1790, Rodney Clemens versus Wexford Health Sources. Mr. De Leon, correct?
That's right.
Good morning.
Good morning. May it please the court. The question here is whether the district court erred in finding that no reasonable jury could find that any of the defendants were deliberately indifferent to Mr. Clemens' foot condition. Now, the district court did at least consider three pieces of evidence that I think are very important to one of the most salient instances of deliberate indifference on
Mr.
this
De Leon,
record.
before you go too far, you're saying any of the defendants. Dr. Funk was a defendant below. I don't see anything in your briefs challenging the district court's ruling finding for Dr. Funk. Are you appealing the ruling as to Dr. Funk?
No, we're not. We're not proceeding on that
So
one.
the way I read your brief, you're focusing on Dr. Obasi and Wexford.
Correct. That's right. So yeah. So I want to focus on three of the different facts that the district court did consider as to Dr. Obasi and Wexford for one of the periods of a deliberate indifference that we think is clearest on this record, which is this 5-year referral delay. So first was the Wexford UIC contract, in which Wexford gets a certain number of referrals every year that it can make to UIC that are covered by the contract, but above and beyond that, each additional referral incurs additional cost. The second are the 2014 and 2015 Wexford performance evaluations of Dr. Obasi, who is then medical director for Stateville Correctional, in which Dr. Obasi says that he's doing a good or even a great job in his self-assessment of keeping costs low for Wexford. But Wexford disagrees and says he's actually not meeting performance requirements and that he's over budget in the areas of off-site care. He has to take immediate steps to come up with ways of keeping costs yet lower. The third is Mr. Clemens' testimony about his conversations with Dr. Obasi about his foot condition.
Hold on, testimony or affidavit testimony?
Yes, right, his declaration testimony about...
Because he said not a word about that in his deposition.
Well, actually, in his deposition, he was asked open-ended questions about, do you have anything else that you want to talk about? His job in his deposition is to answer the questions that he was asked.
I would have thought, Mr. De Leon, so I don't know that it's a sham affidavit. But I got to tell you, it's fishy. It is a fishy affidavit. You would have thought that if his whole theory of the case is that his treating physician said, you need to see a podiatrist, I can't refer you because referring you is going to cost money. I would have thought that that's what he said every other line in that deposition, even in ways not responsive to questions. I didn't see anything like that.
Well, what you can see in this record is that
It's like his whole theory of the case is missing from his deposition. That's odd.
I actually don't think that it's that odd given this record, because this all centers around these conversations that Mr. Clemens had with Dr. Obasi, right? And in his grievances, he several times will talk about that he had conversations with Dr. Obasi about offsite referrals, and that Dr. Obasi was saying, well, Wexford's kind of standing in the way of that. Then, and that was in the record, and then in Mr. Clemens' amended complaint, he specifically says that Dr. Obasi said, you need to see a podiatrist, but you're going to have a hard time seeing that because of Wexford.
And what you have in mind is the single reference in paragraph 30.
Well, there is that reference. It's an allegation that's in the amended complaint. And look, his job is to answer questions honestly when he's asked in his deposition. It's the attorney who's taking his deposition's job to ask the questions that they want answered. They could have asked him about those conversations, which he did allude to, and yet he wasn't asked about those. So then his job on summary judgment, when he is responding to Wexford and Dr. Obasi's summary judgment motion, is to then show why there's a disputed issue of material fact, which, as he followed his job under Rule 56C, and he included this declaration, which, as the district court said, and again, she's being reviewed for abuse of discretion on that, is really consistent with and it builds on his deposition testimony and the evidence that's in the case. So with that declaration testimony, what Dr. Obasi has said is that, look, you need to see a podiatrist. Unfortunately, I can't refer you right now not because of a medical reason, but because I'm at my offsite limit right now. So if you return to me later, then I'll be able to get you in then. And every time Mr. Clemens returned to him after that, the answer was always the same. I'm at my limit.
All along, Dr. Obasi is treating him, including with prescribing the one type of the New Balance shoe, the high top new, right? Treating him in a way that he's reporting back, the shoe's working. And he's prescribing pain management. He's giving him the brace. He ordered an X-ray at one point in time. He gave him knee soles or insoles. He gave him a knee brace. I mean, Dr. Obasi is doing an awful lot to be exhibiting deliberate indifference to Mr. Clemens' health condition.
Well, the standard for deliberate indifference is, does the doctor know something that he's supposed to be doing in his medical judgment, and he doesn't do it? So Dr. Obasi is
Well, it's a little higher than that. It's, does he disregard a substantial risk of harm or do something approaching a total unconcern for the prisoner's welfare in the face of serious risks? And I think Judge Scudder's point is, if you look at the record, Dr. Obasi is seeing him at almost monthly at one point. How could that be a total unconcern for his welfare?
Well, it's a disregard of a substantial risk. So,
I'm quoting from our case law.
Right.
It's a high bar because it requires showing of something approaching a total unconcern for the prisoner's welfare. That's what deliberate indifference is.
There's also, right, as part of your case law too, that the patient does not have to be literally ignored.
So how would all of the care that he got from Dr. Obasi, how could that have been deliberately indifference, that Dr. Obasi was ignoring him or disregarding a substantial risk?
Well, because particularly after the point at which Dr. Obasi had been prescribing these wide-toed shoes, and he had been getting these wide-toed shoes for a certain period of time that were offering him some relief. At a certain point, those wide-toed shoes start getting denied. And if
But not by Dr. Obasi.
Right, but
Dr. Obasi keeps putting in the request for them.
Well, he actually, after the first time the request was denied, he actually waited a full 6 months before he even submitted another request. And there is case law, right, that certain, even weeks delay can sometimes be deliberately indifferent.
But in between there, he sees him, he's offering other treatment. He offers a brace to him, trying other methods since Wexford had turned down the shoes. So Dr. Obasi says, well, let's try some other things.
Well, there's also testimony that what he was telling Mr. Clemens was, you actually need to see a podiatrist for this foot condition.
So let's assume that's true.
Yes.
And we view things in the light most favorable to your client.
Right.
How do you get around the fact that when he did go see a podiatrist, the podiatrist ordered essentially the exact same course of treatment that Dr. Obese was treating him?
It's actually a little bit different. So Dr. Obese was giving some of these wide-toed shoes, but what the podiatrist, Dr. Keene, said is he actually needs to be getting shoes that are wide enough to accommodate his condition, so they're not actually jamming his feet together and causing a lot of pain that can cause infections and can cause a worsening of the disease. But it also needs to have custom orthotics. So the shoes need to be wide enough to accommodate, and then he needs to have custom orthotics so that they're being held in place, both to alleviate the pain, but also to alleviate the progression of the condition. As our expert has said, if he had been getting the correct shoes, which is what he ultimately got, these wide shoes with these custom orthotics, if he had been given that from the beginning, his condition, first of all, he would have alleviated his pain,
Weren't
and
the
second of all,
wide shoes the same type of shoes that Dr. Obese was putting orders in for?
not with the custom orthotics that
Put
could
the
have.
custom orthotics aside. The wide shoes, I think, were exactly the same thing Dr. Obese had ordered, right?
Well, it's part of a package deal, right? So it's kind of like having a cast where you're keeping this condition sort of immobilized so that it doesn't progress to the point where ultimately corrective surgery became necessary.
Wasn't that the purpose of the inserts that Dr. Obese ordered? They may not have been custom, but they were inserts.
So inserts that are in shoes that are too, you need to have both, right? So if you have shoes that are too narrow and then you put inserts on top of those shoes that are too narrow, they're not doing their job, right? It's just further jamming the toes in, and it's making it so that it's actually even more painful because you're making something that's already too narrow even more narrow. If you have something that's wide enough and then you're putting the orthotics in there, and then that's what's actually accommodating this condition and keeping it from getting worse. Kind of
Why isn't there evidence then that Mr. Clemens, I just don't see this at all. Mr. Clemens saying, why do you continue to prescribe the New Balance high tops? They don't work. They don't work. My foot and ankle pain is worse than it's ever been. It's not getting any better. That is not the record before us. The record before us is, in fact, at one point in time, I think he tells a nurse practitioner the New Balance are perfect.
He does say that the wide-toed shoes.
It just seems very difficult against the backdrop of everything Dr. Obese was doing and the statements that are in the record that your client was making to see a jury issue on deliberate indifference here.
Well, put yourself in.
Maybe it's negligence for not doing what were you calling them? The kind of prescribed, the implant, the kind of tailored implant?
Well,
But
I'm sorry.
I don't see it as a deliberate indifference case.
It's more than negligence when the doctor actually says, this is something that requires a specialist, which ultimately it did, because it was Dr. Keene's recommendation that was ultimately followed. And that was what, as our expert has said, if it had been followed earlier, when he should have been referred to him, the need for corrective surgery could have been prevented. So Dr. Obese is telling his patient, I think that you need to see a specialist for this. And especially after he knows that his patient is no longer getting anything that's alleviating his pain whatsoever. Sure, he's making the requests are denied, but what do you do when you're Dr. Obese in that hands? Do you say, when you're in that position, do you say, well, really his hands are tied, there's nothing he can do beyond this? His hands are not tied. He's actually telling someone, well, what you need to do is see a podiatrist, and he's not even making the referral. And he says, there's not a medical reason why I'm not making the referral. I'm doing that solely because of a cost-saving policy. If he had done that, if he's not getting listened to, maybe the podiatrist is going to get listened to. And if he's not, and if he doesn't know what to do to correct this, to actually correct, the progression of the disease, the podiatrist does. And in fact, the record shows that it was the podiatrist who came up with the correct solution, which if it had come up, if we should have known before, would have actually solved this. So I think when you take all that together, I understand it's not that he did nothing, but he was faced. I mean, the record shows that there was 3 instances, at least in 2016, when Dr. Obese saw Mr. Clemens. That is all after he, first of all, as the district court had said, well, look, these performance evaluations, right? These performance evaluations might be able to support a reasonable inference that Dr. Obese was over-prioritizing costs after he received them. Before that, she said, I think a reasonable inference might be that he was just ignoring costs at that point.
So is the deliberate indifference theory like the one that we dealt with in like Greeno what is it, good, cases like that, that a physician is persisting in a known line of ineffective treatment?
Yes, which he is at that point. And, after the shoes are no longer being prescribed in 2015, he knows, and his patient is constantly coming back and telling him, I'm not getting any relief. I used to be getting at least these wide-toed shoes, which were helping a little bit. And and especially when the doctor actually has an idea, this is not a negligence thing, because it's not something where the idea didn't occur to him. When he says, really what you need to do is go to a specialist, he should order the specialist, and you should make a referral to a specialist, and not doing that when you know as a doctor that that's what your medical judgment is saying that you should do, and the reason why you're not doing it is because you're following a cost-saving policy. That does get to deliberate indifference, because again, these periods in which he was talking to him in 2016 after he's no longer getting the shoes, those are after he starts getting the performance evaluations, which even as the district court said, could support an inference that he was over prioritizing costs at that point.
Mr. DeLeon, you want to save the rest of your time for rebuttal? You don't have to. You can use it now.
Yes, am I in my time for the 10 minutes or for the full 15 minutes?
Yeah, so you have an overall 45, we'll round it up, but that's the total time you have left.
Okay. I will reserve the rest of my time for rebuttal.
Okay.
Thank you.
And no problem. Let's hear from, is it Mr. Craig?
Please the court. My name is Patrick Cray, representing Wexford, Dr. Arthur Funk, and the estate of Dr. Sala Obasi. The district court's order granting summary judgment in favor of these defendants should be affirmed. First, to your honor's point, and as Clemens conceded, he's abandoned any challenge to the district court's grant of summary judgment to Dr. Funk by failing to address that order on appeal. Regarding Dr. Obasi, this court should affirm summary judgment in favor of his estate because no reasonable jury could find Dr. Obasi was deliberately indifferent in treating Clemens' complaints of pain. The chronology of medical care here shows Dr. Obasi consistently submitted requests for shoes that Clemens sought, and his operative complaint here claimed that he was stopped receiving the shoes that he had been given, that were being prescribed for him, and the notion of not being referred to a podiatrist due to cost was not the main allegation in the complaint. We're addressing those shoes. These orders for special shoes were entered in addition to orders for an ankle brace, shoe inserts, and pain medication. And from 2012 through 2015, Clemens received these shoes that he requested, and Dr. Obasi on multiple occasions wrote permits allowing Clemens to continue to wear those shoes. Clemens admitted to multiple other physicians and in his operative complaint that Dr. Obasi's plan of care worked for him, and the special shoes actually helped his pain. Clemens' frustration in this case stems from Collegial Review eventually approving an alternative plan of care where those special shoes stopped being ordered. This had nothing to do with Dr. Obasi, who then continued to submit requests for Clemens to receive those shoes after Wexford adopted an alternative plan of care.
Mr. Craig, let's assume for a second that the court deems the affidavit, the declaration, the post-deposition declaration, summary judgment declaration, a non-sham affidavit, in other words, appropriate. Can you still win?
Sure. As the district court noted, even if the declaration is not a sham affidavit, no reasonable jury could find that Dr. Obasi was deliberately indifferent for not referring Clemens to a podiatrist any earlier than he did in 2017. Dr. Obasi's treatment decisions are presumptively valid, and liability may only be imposed if no minimally competent professional would have done as he did. And this treatment plan in this case, as Clemens admitted to multiple treaters.
Does it matter or create an issue of fact that the reason he didn't send him was allegedly for financial reasons as opposed to just a disagreement in treatment?
If the affidavit is not a sham affidavit and the reason is cost, it would only create a tribal issue if it was cost with excluding reasonable medical judgment from the equation in addition to considering cost. And in this case, it cannot be said that reasonable medical judgment was skewed in favor of just cost because an alternative treatment plan was ordered prior to the podiatrist consult in 2017.
But what he says in paragraphs 6 and 7 of that affidavit are, they're pretty direct.
The issue of not being referred to a podiatrist at that time due to cost, even if that declaration statement is taken as true, it removes from the equation that there's still exercise of reasonable medical judgment in ordering an alternative plan of care. With the special shoes that Clemens admitted helped him, he also received insoles and an ankle
What do you
brace.
do about the way paragraph 6 opens? Dr. Obasi agreed that I needed to see a specialist for my condition.
If Dr. Obasi needed to see...
Comma, ellipses, etc. I mean, that's a pretty declarative statement.
First off, the medical records from Dr. Obasi's plan of care this time do not reference the need to see a podiatrist whatsoever. But assuming that these conversations happen as the declaration states, again, it's telling that when he actually does see a podiatrist, 5 years after he first sees Dr. Obasi, the podiatrist recommends almost a mirror of kind of care. Same shoes, the ankle brace, the pain medication, it's all the same. So there's
What
no...
about Mr. De Leon's argument that the soles and inserts were customized from the podiatrist as opposed to what Dr. Obasi was doing, that's a significant difference?
Well, as our expert testified that the shoes are still wide enough to accommodate the hammer toes and the bunions that were the ultimate conditions in this case. And to your Honor's point before, even if Clemens' contention is true that the insoles weren't perfect for his feet and weren't alleviating his pain, that doesn't amount to deliberate indifference. That may be an issue of facts with regards to a negligence claim, but he's still receiving care for giving him wider shoes, giving him an insole to accommodate his bunions and his hammer toes, and that does not equate to deliberate indifference in this case, even if his allegations are true in the declaration and assuming that the insoles he got were not proper for his bunions and hammer toes.
Mr. Craig, my words, not yours. I agree with you that this affidavit is very fishy, but that's not the test. Why is it a sham affidavit?
Sure. Well, I'll get into the issue of cost. To your point before, while Mr. De Leon was speaking about how cost isn't referenced in the deposition testimony at all, both the district court and Clemens ignored an important contradiction that was included in the declaration, and that being Clemens testified that his complaint about Dr. Obasi's care was that he did not appeal any collegial review decision from Wexford.
In his deposition, that was one of his primary concerns.
That was one of his primary concerns with Dr. Obasi. And then in his declaration, he states that Dr. Obasi never referred Clemens to a podiatrist for off-site specialty care in the first place due to this concern over cost. This is a major contradiction that goes toward the heart of Dr. Obasi's conduct in this case. And the district court found that the declaration served to build on statements Clemens made during his deposition. But the declaration added statements that cost was the reason as to why...
So can I get nitpicky with you?
Sure.
Why is that a contradiction as opposed to a fishy supplement?
Sure. So review of the medical records shows that a podiatry consult was not contemplated at all by Dr. Obasi. Then you have the deposition testimony, which states that why Clemens was bringing this lawsuit in part was because Dr. Obasi had ordered the special shoes and the consult, and Wexford was not approving all of his orders in collegial review, and Clemens was filing this claim against Dr. Obasi for not appealing those collegial review decisions, even though he was continuing to submit the orders for special shoes and consults. Now he's saying in the declaration that none of that happened. He did not submit those requests to collegial review because he told Clemens from the outset, I can't send you out to a podiatry because I have these referral limits and there's this issue of cost. None of that's mentioned in this deposition. This is new material that contradicts
Is that
the deposition.
inconsistent? It might be new material, but is it inconsistent or does it contradict anything in the deposition?
I believe changing a story that Dr. Obasi didn't do certain things in the first place due to cost is inconsistent because he testifies during his deposition that he did submit those orders. It was Wexford's issue of collegial review not approving those orders that they previously approved, specifically.
Was he represented by counsel at the deposition?
He was represented by counsel during his
Yeah,
deposition.
I have I for the life of me, I can't think of why in the world he wouldn't be talking about this cost consideration in response to every other question.
I agree, Your Honor. The district court found that this declaration served to build upon the deposition testimony, but this is a completely new theory that was not discussed at all during his deposition. It's not building onto it. It's constructing a whole new argument to try to avoid summary judgment. It's not a coincidence that there was no notion that cost was a part of Clemens's claims until after the summary judgment motion was filed, at which point this declaration was filed, which mirrored the allegations and facts from a case that was decided after the deposition, where Dr. Obasi told an inmate in a different case, I can't send you off for this referral because of costs. Well, none of this was testified to at his deposition. This is all new material that is not found anywhere in the record, and he's relying solely on that declaration to prevent a finding of summary judgment.
Can he consider cost? I mean, what's wrong with that? I mean, it's one thing if he says, I'm not going to send you to a specialist because of the cost, and I'm going to stop treating you, as opposed to saying, I could send you to a specialist, or I would send you to a specialist, but for the cost. It's extraordinarily expensive, and I am going to continue to treat you like this. Come back in 6 months and we'll see if it's effective. I mean, I think doctors across America do that a lot. We're hearing a constitutional claim.
Right. This court has found on prior occasions that correctional healthcare systems can't consider cost. It just can't be done to the exclusion of reasonable medical judgment. So even assuming the declaration is true and considered by this court as it was by the district court, cost can be considered. It just can't be done to the exclusion of reasonable medical judgment. And we contend that that's what happened here, because a reasonable alternative treatment plan was ordered at all times. And again, Clemens admitted to multiple other treaters, and he alleged in his complaint that alternative plan of care was working for him. I agree that cost can be considered, just not to the exclusion of reasonable medical judgment.
Just not to the exclusion of other treatment, right? I mean, he could sit there and say, well, I could send you for an X-ray, I could send you for an MRI. Hell, I could even send you for a CAT scan. But I'm not going to do any of that because of the cost. Instead, I'm going to continue to treat you conservatively and come back and see me in 6 months if these shoes aren't working.
Agreed. And again, from 2012 to 2015, when he was receiving those shoes, he's agreeing it's helping them. And when the podiatry consults first ordered in 2017, when Dr. Obasi recognizes that the bunions and hammer toes have progressed to a certain point, during all these times, he is ordering an alternative plan of care that is reasonable, and again, telling that the podiatrist in 2017 ordered substantially similar care to what Dr. Obasi ordered 5 years prior, and the ultimate surgical intervention in this case that occurred in 2020 was still 3 years after a podiatrist was consulted in the first place, which would go towards the delay claim. I just want to touch on the Monell claim against Wexford with my remaining time. This court has described 3 types of corporate actions that may give rise to Monell liability: an express policy of a corporation that causes constitutional deprivation, a widespread practice that is so permanent and well settled it constitutes customer practice, or a constitutional injury resulting from a person with final policy-making authority. Here, the purported cost savings policy regarding the podiatrist referral by Clemens' own admission is unwritten and not express, and Clemens failed to produce evidence concerning treatment of any other inmates. He also doesn't identify any person with final policy-making authority. He does not contest that his Monell claim concerns only the period of time of Dr. Obasi's medical care, and he also concedes that he's wholly reliant on his own experiences in order to prove his Monell claim. Given all these concessions, creating a genuine issue of material fact from that scenario regarding systemic deficiencies of an inmate's own experiences is an extremely difficult task. He concedes that he's also reliant on one experience of cost-cutting measures enduring over a period of multiple years, and that one experience is not sufficient to show a widespread customer practice. His sole argument on appeal is that a single application of an offensive policy resulting in a constitutional violation can be sufficient to establish a Monell claim, and he relies only on the Calhoun versus Ramsey case. But Calhoun supports that one application of an offensive policy can be sufficient only if the policy itself explicitly violates a constitutional right as enforced. But the unwritten policy here, as we discussed regarding cost, is not unconstitutional on its face, because correctional healthcare systems can consider cost as long as it's not done to the exclusion of reasonable medical judgment, and this court has also found that the collegial review process by itself on its face is also not unconstitutional. Therefore, the unwritten policy Clemens places at issue here is not facially unconstitutional. And notably, the court in Calhoun proposed a hypothetical scenario of a kind of policy that would be unconstitutional on its face, and it concerns correctional officers throwing away inmates' medications. And after this court in Calhoun determined that the policy in that case was not anything like that, it affirmed summary judgment in favor of the defendants, as this court should hear. At best, On the Monell claim, Clemens merely offered evidence that Wexford's actions may have been motivated in part by a desire to minimize costs, but his experience alone in that regard is insufficient to establish an unwritten policy of prioritizing costs affecting many inmates without regard to medical judgment. Unless there are any other questions, we ask this court to affirm the district court's judgment.
Okay, Mr. Craig, thank you very much. Mr. DeLeon, we'll give you a minute on rebuttal.
Thank you. So as Mr. Currier had said and others have said, cost can be a permissible factor, but it can't override medical judgment. Here, the testimony is not that Dr. Obasi said that cost was a factor. He said it was the factor. He didn't give any medical reason or justification for delaying the referral. In fact, he agreed with Mr. Clemens. He said, you need to see a podiatrist, and I'm just not going to do it because I'm at my limit. And, try again, try again, try again. Maybe if there was one time in which he said, I'm not going to send you out right now because I've got a different treatment plan, and then, after 6 months he went and did that, that would be one thing. But this is over the course of 5 years. That's the testimony. Try again, try again, try again, never with giving a medical justification for the delay. And I understand, as you said, Judge Scudder, that this is, you see it fishy. I've heard it said that this is self-serving. As the Seventh Circuit has said, self-serving testimony is testimony. That is why we have juries to decide whether things are credible or not credible. They could make the same inference that the district court did or that the other side urges you to make, but that they haven't had the chance to do that. That's why a jury trial is necessary to resolve these genuine issues of material fact. Unless there are further questions, I'd ask that you reverse the district court.
Okay, very well. Mr. DeLeon, thank you very much. Mr. Craig, thanks to you as well. We'll take the appeal under advisement.
Thank you.
Okay, our fourth argument of the morning is in appeal number 23-2473, Mesenbring versus Rollins Inc. And Mr. McKnight, good morning.
May it please the court, my name is Neil McKnight. I represent Melissa Mesenbring. She's the executor of the estate of Derek Mesenbring and the mother of their two children, Candace and Jackson. As the court knows, Mr. Mesenbring died of methyl bromide poisoning while in the employ of IFC. And the primary issue in this appeal is the application of the doctrine of direct participant liability as it applies to Rollins, who's the parent company for IFC. The trial court erroneously concluded that there was insufficient evidence to defeat the defendant's motion for summary judgment on this topic. But in doing so, the trial court made determinations of material fact regarding a number of pieces of evidence. The first and primary piece of evidence was the interpretation and characterization of Rollins' approval level guide.
Say that again.
The Rollins approval level guide. The Rollins approval level guide was a set of mandatory procedures that Rollins used to control and determine expenditures, including some day-to-day expenditures of Rollins' wholly owned subsidiaries, including IFC, where Mr. Mesenbring worked when he died. The trial court erroneously characterized the approval of the guide as a method by which Rollins' subsidiaries could request capitalization of expenses. But the guide is much, much broader. And the evidence does not support the approval guide was used solely for the purposes of requesting capitalization of expenditures. To the contrary, the evidence of the guide itself suggests that it was used for a broad number of different concepts. And in fact, the testimony of Mr. Levitt, who's the Rollins employee who characterized himself as the president of IFC, specifically said it was part of a decision to see whether or not Rollins wanted to capitalize the expense or was going to be a capitalized expense of the underlying subsidiary. To the point of the determination, and the trial court said, hey, that's what this is about, and so this doesn't rise to the level of what the Forsyth court called eccentric budgeting, where you're going out of the ordinary to get involved in the day-to-day decisions. And if you look at the
in a way, right, that would create a foreseeable risk of injury here to the party injured.
Certainly.
Yeah.
And so the overview to the guide specifically provides as follows. The Rollins Approval Level Guide should be utilized to assist with purchases and business decisions. Use it to determine required approval levels and the routing of emails and applicable paperwork. The approval level guide must be adhered to at all times. And in fact, Mr. Levitt describes it as applying to IFC, but then he later describes it, contradicting the express language of the document, as for the purposes of awareness only. The trial court made the factual determination by determining the meaning of this document, meaning changing the language of the document itself and ignoring the plain language and accepting the inferences that favor Rollins when presenting the motion for summary judgment. So the court in this circumstance added this sort of addendum to the level guide saying, but it's only for capitalization of expenses, which is incorrect. In reality, the approval level guide addresses a number of different issues. Advertising expenses, it adds to legal settlements, bonus calculations.
I mean, that may all be right, but aren't you at least at this point in your argument, you're still at a level of generality that's divorced from the requisite inquiry? Right? In other words, don't you got to get to the point of saying that the guide and the parent corporation's insistence that the subsidiary, here the employer, follow the guide, right, created a foreseeable risk of injury or death relating to the handling of methyl bromide?
I think it doesn't have to be that specific. I think that's lifting foresight exactly from the sort of language itself, and I think it's a little bit broader than that. But nevertheless, if you look at the testimony of Mr. Levitt says, I set the revenue goals, I set the profit goals, I determine bonus, I determine employment.
Yeah, but don't go the next step.
And the next step is, it should certainly be, and the proper inference from that is that these people who are working at IFC, who are having what were described as unrealistic profit expectations being imposed upon them, taking shortcuts with respect to whether or not there is a proper safety protocol put in place regarding methyl bromide, as well as a myriad of other issues that are presented by the case.
So your point is that from what you just articulated, it's a fair inference.
It certainly is.
That health-related risks would be present with respect to the handling of any particular chemical.
That's correct. And I think one of the other things is that if you look at Mr. Levitt's testimony is, I got complaints about all of my revenue and profit expectations as being unrealistic, but somehow they seem to meet them. Mr. Levitt also specifically testifies that he says, if you're not meeting your profit expectations, you're going to get a talking to, and potentially that could lead even up to termination. So,
how do you get around the Forsyth's conclusion that just mere budget mismanagement alone is not sufficient for direct participant liability? Because that's what it sounds like you're arguing here.
I am arguing, but there's additional facts which the trial court did not address in response to the motion for judgment that we argued in our briefs, and that is the control of the premises. So there's been a lot of discussion about how Mr. Mesenbring died, and there's a number of factors involved. One is the transfer from a large cylinder to a small cylinder. Second, it's the storage within the facility itself, meaning it wasn't under a ventilated hood, it wasn't in a ventilated place, because the requirement...
What's the evidence of control?
The evidence of control is...
over the facility and over the storage facility and the storage containers.
Well, because they controlled the premises, because if you look at the documentation, the evidence presented, subsidiaries of Rollins are the lessor and lessee of the premises where this methyl bromide that poisoned Mr. Mesenbring was located.
So control of the premises as far as access and its use by the subsidiary for its operations is distinct, right, from control of property that's used in the subsidiary's operations, in particular methyl bromide.
Well,
so that's why I wonder are you stopping one level above where you need to go?
No, I'm going a little bit further, because one of the things that's been discussed is whether or not this was a capital expense. that applies to Rollins, and that was specifically stated in the documentation. In addition,
But even if it was, how does the control over the lease and the obtaining of the property establish any kind of control over the activities here that caused the accident?
Because IFC could not, under those circumstances, requested the appropriate fixtures or the appropriate improvements to the structure itself to allow the proper storage of methyl bromide. But it goes further than that. The evidence is
But
even...
what precluded IFC from purchasing those things itself?
Because that's part of the approval level guide that's driven by profits and bonuses
But
down
isn't
the
that
road.
just if they want Rollins to pay for it as opposed to pay for it
No,
themselves?
the approval level, that's the point of the approval level guide. It applies not only to Rollins, but it applies to the subsidiaries themselves. And it's not a question of whether Rollins is going to pay for it.
Is there any evidence that they ever requested any additional safety measures at the facility that were turned down?
They did not. That evidence has not been presented. But I will say this: what did happen is, if you look at the IFC protocol and the standard operating procedure, there's no mention anywhere in IFC's standard operating procedure about how to properly store. Should it be in a ventilated place? In fact, Mr. Ponton, who's asserted that he is the what I will call the penultimate employee of IFC, described it as being a label description. And if you look at the label description, and he describes it himself, it's to put it in a well-ventilated place. There's no analysis done by IFC whatsoever regarding whether or not this is an appropriate place to store methyl bromide, because they're not in control of the premises. Why would they ever do that? Next, after Mr. Mesenbring's death, what happens is there's an investigation. But that investigation is conducted by Rollins. Rollins hires the engineers. Rollins conducts the safety audit of the premises.
What's the relevance of all of those activities after the fact? How could that be evidence of foreseeability?
Because that shows after the Illinois Department of Public Health and OSHA determined that it was improperly stored, and that was the basis of the fines that were imposed upon IFC regarding that, that Rollins had control of the situation. Rollins ultimately...
But all of that is after the fact.
That's right. That's
I'm
a
not sure
remedial
how
measure.
that helps you.
But that's under Rule 407 of the Rules of Evidence. That's an exception to the barring of that because there's a question about whether or not there's a dispute as to control. And so for those purposes, those documents, those recommendations all come through Rollins. And then Rollins issues the memo describing how IFC should do its work in transferring, because what ended up happening is Rollins said to IFC, we don't want you transferring from large cylinder to small cylinder anymore. And then they went out and sought...
But the fact that they're making, maybe this is Judge St. Eve's point, or at least the fact that they made some improvements, Rollins dictated them to the subsidiary after the fact, doesn't prove, the parental participation, the parental direction in the first instance.
Well, I think it does, because if you read it, if you look at it in conjunction with the lease, where they have no control over it whatsoever, that falls within their rubric to decide what to do and make sure that the property...
But there's nothing about the lease that says IFC has no control over what goes on inside of the premises.
IFC is not a party to the lease.
I understand, but that doesn't dictate what's going on inside of
But
it.
if you look at the subsequent measures taken, they characterize it, meaning Rollins characterized them as capital improvements to the premises of which they control through their subsidiaries, that they sign off on, that they approve. There's no involvement in IFC whatsoever, other than the argument is this is one of the smorgasbord of services that we request that Rollins do for us. But in reality, what ended up happening is these subsequent remedial measures reveal that they were in control of this portion, the configuration of the building itself, and the decision whether or not to install the appropriate equipment to avoid a very foreseeable accident when you have human occupation together with the storage of a chemical. And then at the end of this whole process, if you look at the decision tree analysis that's provided, what we have is a situation where the decision tree analysis is directed to Rollins. There's a discussion of what we'll call Mr. Mesenbring's death, but the next analysis is applying it to all of Rollins' facilities and all the physical facilities that are controlled by IFC where methyl bromide is stored. And in fact, there's a series of recommendations that are made. That's evidence of control. And in light of the absence of any other standard operating procedure provided by IFC, that is a situation where they filled the gap. And the gap should have been filled by them all along. They knew that IFC was using methyl bromide. They own the building. The building requires improvements, and they didn't do it. I'm going to reserve the rest of my time.
Yeah, no, very well. We understand your position.
Thanks.
Yep. Mr. Lee, good morning.
Good morning, Your Honors. May it please the Court, my name is Josh Lee. I'm here on behalf of the appellee, Rollins Inc. The first thing I would like to focus on is what was actually decided by the District Court and what is the material portion of that decision. The material portion of that decision focuses on the causation requirement set forth by the Forsyth Court, the Illinois Supreme Court, in the Forsyth case. And what was decided below is whether Rollins, the parent company of IFC, which is the company that employed Mr. Mesenbring, whether that parent corporation can be held liable for Mr. Mesenbring's work-related accident under an exception to the normal rule that parent companies cannot be held liable for acts of their subsidiary. And that exception is called, appropriately, the direct participation exception in the direct participation theory of liability. All the parties in this case agree that Forsyth is the controlling precedent, and at the summary judgment stage, Forsyth requires the court to ask three questions. First, in conjunction with Rule 56, is there a material question of, or a dispute of material fact? There we go. Second, if there is a dispute of material fact and that dispute is genuine, could the evidence reasonably support a conclusion that Rollins exercised what's called eccentric control over IFC? And then third, if there is some evidence of eccentric control, was the conduct of Rollins using that eccentric control a cause of the accident? In this case, what the district court concluded after examining all of the evidence is that Rollins could not be held liable because there was no evidence that Rollins did anything that caused the accident. So regardless of whether there's a question over the approval level guide or not, it's not material because the evidence simply doesn't tie any of the alleged conduct to Mr. Mesenbring's accident.
You agree, though, that I think the point that is being made by your adversary is that he's not using these words, but this is basically what he's saying is this can be shown indirectly. It can be shown by circumstantial evidence. What inferences are fair, especially when you view the evidence in the light most favorable to the non-moving party.
So you could do that if there was evidence actually linking any of the conduct to
Because
something.
direct participation liability, the Illinois Supreme Court did not say you need direct evidence of direct participation liability. It can still be shown circumstantially.
Not on the causation front, Your Honor. You would have to have, well, you could have circumstantial evidence, but in this case, there's no circumstantial evidence that leads us to a link between the alleged conduct.
Yeah, so that's more of a fact and evidence point.
Well, I think the facts and the evidence are tied together. Yes, it is a fact and evidence point. But in this case, you have to look at the evidence and what they've alleged and see whether it actually leads to the accident. And there's a couple of pieces of that. So first of all, if we were to take the approval level guide, for instance, let's assume that the plaintiff's, the appellant's interpretation of that is correct and there were approvals that were required. There's no evidence that IFC ever asked for an approval or asked Rollins to pay for something or approve an expense that was denied, much less any expense that led to the accident. We can look at the lease.
The much less part, though, is the part that's legally significant, right? In other words, that's the part of this that I think it has to be analyzed at a high level. It's somewhat of a high level of particularity. It's not like they requested approval to put in a new parking lot and it was denied. You'd say, what's the parking lot have to do with anything? right? In other words, what you're saying is there's no expenditure that was requested that bears upon the handling of chemicals, including toxic chemicals.
That's correct, Your Honor. In fact, there's no evidence.
Is that the right question to ask? Because when you say, well, there's no evidence they did not lend approval to an expenditure, I think, well, you got to tie it to the chemical that caused the death.
You do, Your Honor, but even before that, you'd have to show that they denied some expenditure. There's no evidence of a denial or a disapproval of any expenditure at all in this case. So you can't even get to the second question because there's no evidence that Rollins ever disapproved.
What do we know
any
about what
expenditure.
Rollins required, said, suggested by way of any kind of training materials that bear upon the handling of chemicals?
What we know
Training employees, ensuring their safety, etc.
What we know about that, Your Honor, is that, and it's important to understand this, Rollins, or IFC, the employer, actually existed since 1937. It was purchased by Rollins in 2005. Prior to, and this is admitted in the statement of facts, prior to that purchase, IFC had its own health and safety department, and it wrote its own standard operation procedures with regard to how chemicals, including methyl bromide specifically, needed to be handled by the employees. After the purchase, IFC maintained its own health and safety department. It did all of the training with regard to methyl bromide and the handling of chemicals. Rollins was not involved in any of that. Rollins Health and Safety Department was not involved in any of that. And the reason for that, and I think that's important in this case, the testimony is because this was a highly specialized area that IFC specifically did. And so Rollins didn't want to do anything that would override IFC's own discretion in determining how best to run its business and train its employees and store those chemicals.
What about the learning management system?
Yes.
Why wouldn't that raise an issue of fact on the training?
It doesn't raise an issue of fact because there was nothing about methyl bromide or the handling of those chemicals that was part of that training. More importantly, the testimony was that except for generalized OSHA required training, ladder safety, it was actually IFC that determined what training went into the learning management system for its employees and what training was required for its employees, and that was not done by Rollins. Effectively, Rollins provided a distribution platform, but didn't determine the content. With regard to the lease, Your Honors, it's simply incorrect to say that IFC was not a part of the lease. You have both versions of the lease. There was only an amendment that was later added. IFC was the original owner of this facility. This facility was owned by IFC when it was purchased by Rollins. IFC occupied and had control over the facility. It continued to occupy and have control over the facility exclusively after the purchase. There was a typo on the extension of the lease, but everybody agrees, and all the testimony is, that IFC continued to maintain and operate that facility, and in fact, the terms of the lease were that IFC had to be delivered exclusive possession of the facility and was required to maintain that facility. Not Rollins, not any other company. And so really, all of this comes back to there's no conduct by Rollins that is any way related to Mr. Mesenbring's accident. Unless the court has additional questions, I think I am done with my argument.
Okay, hearing none, Mr. Lee, thank you.
Thank you.
Okay, Mr. McKnight, back to you for rebuttal.
One thing I would point out is that the training that IFC provides is that it's only with respect to application. And this goes back to my point of
What do you mean?
meaning application of methyl bromide. It doesn't talk about where to store it, what type of circumstances should the canisters be in. Should they be in the same space that people are occupying for human habitation or human occupancy? There's none of that. That's not in the IFC standard operating procedures. There's a lot of
But there's nothing that Rollins provides that tells you how to store or handle it.
They do as the remedial measure. They do. They describe it in particular.
What do you mean?
Meaning they specifically describe how it's properly stored when they do the analysis post-investigation.
But there's nothing in terms of the training where they're in charge of that, or they instruct IFC employees on how to handle the chemicals.
They don't. They don't. But and this is
How
what
do you get around the causation point then?
the way you get around the causation point is because they have. If you look at the totality of the evidence here, the totality is that the guide requires approval. The guide is the basis by which they determine bonuses. Mr. Levitt, who by the way is a
But you're giving us pieces of evidence that might talk about control or involvement of the parent, but that conduct under the law has to cause the accident. So what's or are you disputing that's what the law is? Or
I don't think the finding of foresight is so specific that that's what it is. For example, I think.
What about subsequent cases from the Illinois courts that have interpreted it that talk about causation?
I think there's an element of it that does require a connection to causation, but it doesn't have to be so specific where we unbundle, for lack of a better description, and dive down into a microscopic look at things. You can have a general protocol of safety over what the underlying.
It's got to be foreseeable. Can we agree upon that?
Well, it does have to be, and certainly foreseeable in this circumstance, that when they took control of the building, and they knew that IFC was doing methyl bromide, and they also did applications of their own methyl bromide. In fact, Mr. Levitt testified that he applied methyl bromide, that they understand that it's certainly foreseeable that when you walk into a building that has no or improper ventilation or hasn't even evaluated the building for ventilation, that's certainly foreseeable that you should have proper ventilation and those type of things should be done.
Are you disputing that control is required under the law? That's what the district court's focus was, and I did not see you disputing that in your briefs.
I think what it is that the evidence, as you look at it in its totality, and with the inference to the plaintiffs, you have to establish that, or you have to see that there is control. They've exercised control a number of different areas. What they've done is they've simply decided that, oh, there's no mention of methyl bromide, so therefore it was something that belonged to IFC. And I don't think that's right, because Rollins dipped down on a number of different occasions on a number of different topics relating to safety. And they did it without request from IFC. They imposed it upon them. And then at the end of the investigation, we look at the situation, they impose it upon again. And the last thing I want to talk about is, and I'll be brief, is that they're very sloppy. They're very sloppy. It's not a typo on the lease. It's a complete change of the parties. Mr. Levitt is not an employee or wearing two hats. He wasn't appointed by a board of IFC, because IFC's governance structure requires a board and appointment of officers. Never done. Completely ignored. They've ignored the formalities of the
okay, we
LLC.
got it. I mean, you argued this. We got it.
And I think for the reasons why is that the court made an inference, the trial court made an inference in favor of Rollins versus, as Your Honor described, the circumstantial evidence across the board suggesting control, which should have made it a question of fact, and therefore the summary judgment shouldn't be entered, and we ask that the matter be returned to the trial court.
Okay, very well. Mr. McKnight, thanks to you. Mr. Lee, thanks to you. We'll take the appeal under advisement.
Thank you.
Our fifth argument of the morning is in appeal number 23-2765, Nikolai Anderson versus Mott Street. Mr. Brown, correct?
Yes. Good morning, Your Honor.
Good morning. Nice to see you. Go right ahead.
May it please the court?
Yes.
Your Honors, my name is Attorney Sean Brown. I represent the plaintiff, Nikolai Anderson, in this appeal from the district court's grant of summary judgment in favor of the defendant appellee, Mott Street. Your Honors, the plaintiff should have survived summary judgment for several reasons. In reviewing this matter de novo, the claims submitted by the plaintiff show that there were genuine issues of material fact concerning the claim of sexual harassment sexual discrimination, as well as retaliation.
What's your strongest argument on the sexual harassment? The evidence has to support that the conduct was so severe or pervasive, and all you've identified are 4 or 5 individual incidents over a 2-year period, some of those involving patrons of the store and not employees. How, under our case law, does that come close to sexual harassment?
Well, Your Honor, in viewing the record in the light most favorable to the plaintiff, in the plaintiff's deposition, she specifically talked about 4 to 5 instances of sexual harassment.
Over a 2-year period.
Correct. However, she made additional statements saying that she was touched and groped a lot. She indicated that there were other instances. She just did not go into detail about the other instances that occurred. But to answer your question,
did she lodge complaints in real time? I mean, what you're saying resonates to the extent that it describes the content of her emails.
Correct.
Late in her, but as for example, at the time that she was groped or touched inappropriately, did she lodge a complaint anywhere near the time of the incident?
yes, in the plaintiff's deposition, she indicated that she would report these incidents to Lola verbally, but the actual written memorialization didn't happen until those emails were submitted. So with respect to the sexual harassment claim, Your Honor, there was sufficient evidence for the district court to find that there were genuine issues of material fact. The plaintiff testified that an employee touched her butt. She testified that an employee hugged her several times, grabbing her waist and caressing her behind. That puts us at 4 instances. Then we have the fact that she says another employee called her a derogatory name that's, expressed towards females. She indicated that a specific instance where a patron grabbed her breast and butt. That's 6 instances. Then she testified that patrons grabbed her a lot. So, and that's what I was referring to, Justice St. Eve, when I said that she said, during that deposition, there were instances, but there were so many of them that she couldn't describe each and every single encounter.
But when in a lot of these cases, though, when you're talking about allegations of a workplace environment being so severe, the sexual harassment being so pervasive, one of the things that we often look for is evidence that the employer was on notice of it, right? Because you're not if we give the position you're advancing all the benefit of the doubt that multiple patrons inappropriately touched her, right? You would expect her to be raising that to her employer, saying, why aren't you doing something about this? Or I can't continue to work here as long as you're going to allow patrons to do this kind of stuff. And and you just don't see it. You see it in that email right before the termination.
Justice Scudder, with respect to that issue, the record has profound information concerning the plaintiff going to managers, telling them, hey, this person's touching me. She actually went to the owner and told the owner about, how these people were groping her, and she asked the owner.
What's the record evidence of that? Is that are you thinking about her deposition testimony?
Yes, I'm referring to the deposition testimony.
And these are all these oral reports?
Yes, with respect to that, everything is an oral report except for the emails that were sent on August 26th.
I thought she testified that she complained to Lola, not to the owners, about several of these specific instances. But I don't think she testified that she complained about all these other alleged inappropriate touches by patrons.
There was one instance, the instance specifically addressed in the deposition where the patron groped her breast and behind.
But that's one instance. To qualify for sexual harassment, and inappropriate, completely inappropriate, But to qualify for sexual harassment, it has to be so severe or pervasive as to alter the conditions of employment. And one instance doesn't rise to that occasion.
And Justice St. Eve, I'm glad you brought that point up, because she actually went to the owner and told him about this situation, and he said, okay, we're going to do something about it. But later, the owner went to her and told her, hey, I still need you to wear tight clothing. When she went to him and said, I want to wear looser fitted clothing, the owner told her, you need to wear tight clothing. So that's a situation that,
She wore the same clothes she wore to her law firm job, correct? I think she admitted that.
Yes, that was early on, but however, later on during the course of her employment, they wanted her to wear tight-fitted clothing that would, show off her body essentially. And it was.
According to her testimony, she never changed the way she dressed. She came in wearing what she wore to the law firm.
Judge, I can provide a supplement with the record sites indicating.
That's okay if it's in there, but that's not how I read it.
Okay. So, with respect to the sexual harassment, Your Honor, you indicated that it has to be so subjective and severe to create an abusive work environment, and that's exactly what it was. She went to the owners and as well as her managers repeatedly asking to be moved to a different position because of that conduct. With respect to the second claim of sexual discrimination, the record also shows that men were treated differently than women. The district court looked at only one angle of the prism. The other angle.
Who was your male comparator?
The male comparator would be an individual named Simon. The deposition testimony of plaintiff indicates that.
But the complaint about Simon was that he was coming late, not that he was nasty to patrons coming to the. It's a different complaint. Comparators have to be similarly situated and engage in similar conduct.
That's correct. In the plaintiff's deposition, she indicated that customers would complain about Simon. Simon would use the phone. He would be on the laptop, but
there was no allegation or testimony that customers complained about Simon because he was nasty to them.
With respect to the Yelp reviews, there is not. The Yelp reviews actually don't indicate any party by name as to an individual being nasty or raising complaints. And that's part of the issue with plaintiff's position, is that these Yelp reviews could be talking about anybody, so she doesn't really have any idea who they're talking about, nor can the defendant appellees point out.
I thought, I don't know if it was Mr. Kim or Mr. Chun or somebody, when the Yelp reviews would come in and say we were treated horribly last, Tuesday when we were in for dinner, they traced it back to the work schedule, and they saw that she was the hostess on duty that evening. So it's not just rank speculation. Who are they connected to? They traced it back.
Well, Your Honor, I would disagree with that, because the affidavit is a fishy affidavit. The affidavit comes 6 years after Miss Anderson's.
You didn't argue that below. You didn't argue fishy affidavit or sham affidavit below.
Well, Judge, because at that point, the district court had access to the facts that would show that there's a genuine issue of material fact and dispute for the matter to be tried before a jury. And Your Honor, I'd ask if I could reserve my remaining.
We'll give you, how about we give you a minute on rebuttal? We took up some of your time with questions, so we'll hear from you in a minute. In the meantime, we'll hear from Mr. Sharp, the restaurant's counsel.
Thank you.
You're welcome.
Good morning, Your Honors. May it please the court. Brian Sharp on behalf of defendant Appellee Mott Street. This is really a case about a worker who failed to take accountability. Ms. Anderson was terminated for 8 guests who complained on social media about her rude behavior. And as if that were not enough, she was rude to her bosses, the 4 owners of the company. And at that same time, she was insubordinate to her direct supervisor on 3 separate occasions. That's what led to her termination, and it had nothing to do with her sex or gender, and it had nothing to do with any protected activity that she arguably engaged in. Judge Durkin's well-reasoned opinion granting summary judgment may be affirmed for two separate reasons. Number one, on the merits, and number two, under the doctrine of waiver. Regarding waiver, if I could address that briefly, nearly everything argued, at least with respect to the harassment and the retaliation claims, everything argued on appeal, none of that was argued before the district court. Very little was devoted to the sexual harassment claim or the retaliation claim on summary judgment. The arguments were just a few sentences long in the briefing, very perfunctory, and thus it operates as a waiver when presented for the first time before this court. On the merits, even if the arguments were properly preserved or developed before the district court, there's no genuine issue of material fact on any of Ms. Anderson's claims. The problem is there's just simply no evidence to support them. It's not enough to simply deny facts in a local rule 56.1 statement of facts without citing to some competent evidence. It's
Mr.
not
Sharp,
enough.
I know it's not required under your employee handbook or employee plan, but did your client ever talk to Ms. Anderson or attempt to address the Yelp complaints or his own observations about her conduct with her?
Yes, Judge. There was they call it a counseling session that they had after the first batch of negative reviews came in. Ms. Anderson.
Was that with her one-on-one as opposed to with all of the employees? I thought that was more of a group counseling.
It was more of a group counseling, but she was present and heard the same message that her peers heard about the importance of being kind and respectful to customers or guests who come into the restaurant.
Did they ever talk to her one-on-one?
There's nothing in the record that suggests that they talked to her one-on-one in a separate counseling session, although Nate Chung, her supervisor, was with her one-on-one virtually every single shift.
Is there any evidence that she complained along the way as these incidents were occurring?
Reading the record most favorable to her, she testified that Lola, kind of a lower level.
She managed the front area.
She managed the front. There was testimony that suggests she knew about it, which is speculation. There's really nothing that suggests that she reported it. Now, there are these emails in the record that come much later in her employment, but contemporaneously, there's not much in the record that really suggests that she did report this, other than her speculation that Lola and others knew about it. With respect to the harassment claim, as your honors recognize, the threshold in the Seventh Circuit is very high. It's a high bar to establish a hostile environment based on sexual harassment. In the end, the harassment claim fails because there are 4 to 5 isolated, non-serious instances that occurred over a 2-year period. Under the case law that we've cited in our brief, this just simply is not enough to be actionable. Regarding the sex discrimination claim, under the Ortiz standard, there's no evidence to take to a fact finder to conclude that Ms. Anderson was terminated because of her sex. This is particularly so because 9 of the 10 hosts hired after her were also female. We've identified male comparators who were terminated for similar reasons. The organization is 50% women-owned with many female managers, including Lola, who was promoted from host to manager during Ms. Anderson's own employment. And when it comes to pretext, Ms. Anderson may not believe the social media postings were about her, but that's really not what the question is on summary judgment. The question is, what does the employer honestly and reasonably believe was going on to establish pretext? And she came up short on that front. There's more than ample basis for Nate Chung to conclude that these negative social media postings were about Ms. Anderson, namely that he correlated the schedules. Likewise, the retaliation claim fails because, number one, there was never a legally protected activity, and even if there was, Ms. Anderson in her deposition acknowledged that timing was really the only basis that she was relying upon, which in this circuit, generally speaking, timing alone does not get you past summary judgment on a retaliation claim. Beyond that, we've identified comparators who undisputedly did not engage in any protected activity, and there's no other inference of any sort of retaliatory animus. So if there are no further questions, we ask that this court affirm the district court's grant of summary judgment. And thank you.
Very well, Mr. Sharp. Mr. Brown?
Your Honor, there is record evidence of sex discrimination. I draw the court's attention to appendix page 47 and appendix page 52, in which during Ms. Anderson's deposition, she tells that there were people complaining about Simon. He never had any punishment for using the phone, never had any punishment for using the tablet, but she was. Furthermore, counsel opposite indicates that there is not enough evidence. But in the case of Payne v. Pauley, merely an affidavit is sufficient. Here we have a significant, substantial deposition from Ms. Anderson talking about the wrongful conduct of Mott Street. And her forming the complaints does count as a legally protected activity under case law. Based on that, we ask that you reverse the district court's decision.
Okay. Mr. Brown, thank you very much. Mr. Sharp, thanks to you. We'll take the appeal under advisement. That brings us to our last argument of today's session. It's appeal number 232823, Charles Vabra versus Honeywell International. Mr. Beck.
Good morning, Your Honors. May it please the court and counsel. As you know, this is a retaliation claim under Title VII as well as Illinois state law. My client, Mr. Vabra, who's here, was fired from his job at Honeywell after he refused to go what through Honeywell termed an unconscious bias training program. His complaints about this were in writing. They were numerous. They were very lengthy, and we've reiterated most of them in our briefs. And he said what you would normally think you would get in a complaint of this type. He said, I think this is racist. I think it divides people up into categories. I think it ascribes opinions to people based on the color of their skin, that sort of thing. He actually, at one point on the 24th of March of 2021, said, please consider this to be an official complaint for policy purposes. Honeywell scheduled his termination meeting the next day, and he actually was terminated in a Zoom meeting. The district court held that there was no protected activity. These complaints were not actually protected activity, and also there's no proof of causation. I'm going to focus on the first issue. I think it's legally more interesting. There are two relevant rules in this circuit, and I think in every circuit as far as I know, regarding what is a protected complaint of discrimination for retaliation purposes. The rule is very clear. You don't have to be right as an employee. You just simply have to have a sincere and reasonable belief that something violates Title VII.
How can we say on this record that the belief was reasonable when he never saw the training video?
Your Honor, this court has said, look, you don't have to go through the training itself. You don't have to go through the illegal process in order to know. You don't have to see it in order to know what's in it, that sort of thing.
Is it your position that all DEI training is discriminatory?
Absolutely not. And EEOC, which is amicus in this case, notwithstanding, straight legal compliance training, and I've done probably 500 of them for employers, is absolutely legal, and there's a real public policy reason why that makes sense. What happens is when you get, and I pointed this out before, you get into something called unconscious bias training, that's a little bit different. It draws heavily on the implicit association.
Would we have to conclude that all unconscious bias training is discriminatory in order to find that your client's belief was reasonable?
Absolutely. We're not going to, the EEOC says that that's not the case.
No, I'm asking you, if in order, one of the elements for the protected activity is that your client's belief had to be reasonable.
Mm-hmm.
He admitted that he never saw the video at issue here. So how can we conclude that his belief was reasonable, or even that there was an issue of fact as to its reasonableness when he never saw it?
This court's case law on that topic says that, and I'll refer to the Holland case, which is in our brief, says that this is not supposed to be an insurmountable burden. And I'll quote from Holland, "It has to be the type of activity that under some circumstances could be covered." In other words, under the circumstances here and the specifics of the case, is it possible that this training was in fact illegal to a certain level?
What's the record tell us about the content of the training?
Almost nothing, Your Honor.
Right.
It's very interesting.
Well, that's an evidentiary. I mean, I think that's what Judge St. Eve is getting at. I mean, that's a challenge for your client.
We asked for it. What we got was a PowerPoint deck file, which had very little in it. And clearly, the actual computerized training had more information than that.
So
It
what if
doesn't
you
seem
got
to be
it?
here.
What difference does it make if you got it in discovery? I mean, you could say in discovery, we got it, and we were right. But how would that prove your client to be right if he never saw it when he claimed that he was fired because he wouldn't watch it?
Again, referring back to the Holland case, Your Honor, you have to look at all the facts and circumstances to figure out if it's a reasonable belief. Two things here, and this is very clear in Mr. Vabra's deposition. There was an extremely detailed email from John Waldron.
Got it?
And-
I got that.
And Mr. Vabra actually said, look, if that email hadn't come out, I probably just would have taken the training, but based on that email, I knew what they were trying to do.
Was there evidence that Mr. Waldron created the video?
There's not evidence that anybody created the video, Your Honor. It's been very difficult to figure out the decision-making process.
No, I mean that he said, okay, so Waldron sent this email which I found to be offensive and over the top. Because Waldron also created the video, I believed the video would be offensive and over the top. These videos are required. Whatever you think about them, okay? Sex harassment videos, these are required by employers all over, maybe all over the world.
They absolutely are, Your Honor. John Waldron was the boss.
Right.
He was the guy running the entire division of Honeywell at that time. And this, remember, was after the George Floyd and Breonna Taylor situations. And the information coming out of corporate America was not simply sex harassment training or something like that. It was saying, this is how you should think about race. And remember, this is an unconscious bias or implicit bias training program which says if you are Hispanic, you think like this. It's very different
How
from
do you
saying,
know?
I don't know.
That's what it says.
I don't know
There's-
that we know that.
Exactly. There's nothing in the record that tells us what it says other than a statement by, I believe it was your client's boss, that he watched it and it involved a white man scenario that was determined discriminatory.
Your Honor, I think this gets around to what the standard is if you are complaining about something, which, by the way, is explicitly racial in this case. So this is not like a run-of-the-mill retaliation
What is
case.
explicitly racial?
The training program. It is
How
training
can
on...
we decide that's explicitly racial if there's essentially no evidence about it and your client didn't see it? It would be very different if your client had watched it and came in and said, I found it discriminatory for the following reasons.
Or similarly, that my hypothesis is correct, that there is a straight line connecting CEO or President John Waldron's email, which your client articulated why he found offensive, and the content of the training that I just watched. They are directly related to one another.
Your Honor, I agree. If I had the program and the program said that I think all white people suck, if I could use that language here, okay, that'd be great. We don't have that, and here's the thing.
But we're on summary judgment, right? In the district court, you could have said, could you not, to the district court judge, look, I'm representing a client here. I have to get more information about this training video, or I'm going to have a major problem.
Did you subpoena it?
We asked for it in discovery, Your Honor.
Yeah, and
We
then
did not
when they
subpoena
did,
it
she
because
moved to compel, et cetera, et cetera.
We took the deposition of the then HR director, Your Honor, and she said that's all there is. There is nothing else.
You mean it didn't exist?
Nothing else existed, right?
Did they turn over the training video to you and you just didn't watch it?
No, there was no training video produced.
Okay.
And in their discovery responses, they said this is all there is.
So the training was a PowerPoint, not a video?
That's what we got, Your
And you
Honor.
got the PowerPoint?
We did.
Okay.
And under a representation that the training was to click through the PowerPoint and then at the end say, I took the training?
Yes, that's what their discovery responses said, Your Honor.
And
So,
And I
Okay.
haven't seen anything that you've submitted that any of those PowerPoint slides were discriminatory.
no, we haven't, Your Honor, and they may or may not be. Here's my point, though, and I'd refer the court to the Magar versus St. Joseph Medical case. We're not required, for purposes of a Title VII retaliation claim, to try a case within a case. We don't have to prove that it is, in fact, an illegal discriminatory item in order to support this claim. And here's the thing. There are two rules here. One is you have to show that it's of a type, and that is covered by Title VII. That's the Lord case from this court. But then there's the rule that says you don't have to be right, and that's the Hamner case from this court. Well, I don't know if those rules are in conflict, but there is a certain tension, depending how one takes it.
But
And if
there's
we take,
still an objective test that the belief had to be reasonable. And it would be very helpful to support that, since your client didn't see it, to know something about what was in that PowerPoint that made it discriminatory.
at the time that Mr. Vabra made this decision to forego the training, he sincerely believed that it was discriminatory, and I don't think
I don't doubt that,
Yeah.
but it also has to be a reasonable belief.
The reasonable belief was based on two things at that time. One was the email from John Waldron, and with all respect, Your Honor, I think there is a straight line there because this was the official policy of Honeywell Integrated at the time. And then, when it comes out, it's not simple Title VII training, and Mr. Vabra testified in his deposition that there would be, if it had just been Title VII training, he would have taken it. Why didn't they just do Title VII training? No, it's unconscious bias training, and the court can take judicial notice of the fact the implicit association test, which is the exact same thing, is very controversial, and it does make claims that are considered to be out there, very far removed from simple compliance training. Your Honor,
Okay.
it looks like
Well, we're going to give you a minute on rebuttal. We asked you a lot of questions, and we want to give you your time here. So why don't we pause now? We'll come back to you on rebuttal. We'll hear from Ms. Colvin.
Thank you.
You're welcome.
May it please the court, my name is Jennifer Colvin, and I represent the defendant appellee, Honeywell International, Inc. The district court's opinion should be affirmed. There are no disputed issues of fact in this case, as plaintiff admitted all of the facts set forth in the statement of facts supporting the motion for summary judgment.
As you get started, Ms. Colvin, can you clear up? I sure came into the argument of a mind that I don't know what the training consisted of. I know how it was described, but has your client, did you in discovery produce the training?
Yes, the training was produced. The video was produced and Bates labeled as 1308.
Is there a video? I'm sorry.
No, go ahead.
It was a video training, so both the PowerPoint as well as the video had been produced in discovery. The training itself was...
How could there be confusion about that?
I don't know how there could be confusion about that. It was produced in discovery.
Was there ever an argument before the district court that it was not produced?
There was not any argument before the district court that it was not produced.
So can you just spend a second? So it's we've all done this. We've all done these kinds of things. It's on the computer. It's a video that is accompanied by a set of facilitating PowerPoint slides, and you work your way through them.
Correct.
And at the end,
It was
you're done and-
yes, that is correct. It would have been a self-watched video training that could have taken anywhere between 20 to 30 minutes,
And
depending
is the
how
video
long it
part
is.
of it? Is there some kind of narrative is there a video?
So it contained vignettes or scenarios of situations that might involve unconscious bias. The record does reflect that one of those scenarios involved a unconscious bias against a white man because the holder of the bias believed that a woman would be better suited for the job task. So those were the types of scenarios that were being shown in this video.
And if the panel here had the discovery record, we could go to that Bates number, we could watch the video, and we could watch it with the accompanying PowerPoint slides in our hands, is what you're saying.
Yes, I believe that to be.
And that was produced in discovery?
It was.
All right.
At the end of the day, when you look at this record as a whole, it does not support that a reasonable jury would find that Mr. Vabra was terminated for engaging in protected activity.
Was Mr. Vabra ever warned that he could be terminated for not completing the training?
Yes, that started as early as when the training actually was announced in November of 2020.
Was there an explicit warning? I know it was said it was mandatory, but was there any kind of explicit warning that mandatory means if you don't take it, you're going to be fired?
Yes, when he met with Chris Maines, who was the vice president of engineering, after he had raised his complaint, Mr. Maines did tell him that it would be insubordination.
That was quite a bit later, correct?
That would have been after he made his complaint. Yeah. Up until the time that he made his complaint on March 8th, it appeared that, like many employees, he simply just hadn't gotten around to taking it, right? He had received...
he had a couple of opportunities, even, it seemed, I mean, maybe I'm misreading it, you can correct me if I'm wrong, but even after the stated deadline had come and gone, a couple of his colleagues or managers or something came to him and said, hey, look, are you going to draw a line in the sand on this? Or,
yes,
take that training?
Yes, that's absolutely correct, that on the 2nd of March, he was told that he needed to take the training, that it was mandatory.
That's after the deadline?
That was after the deadline. The deadline was February 25th. He received a daily automated email after the 25th that told him how many days he was out of compliance, that the training was required, and that the matter had been escalated to his manager. His manager then indeed did speak with him about taking it and told him that he needed to complete it within the next 24 hours. HR followed up with him to remind him that it was mandatory training. And indeed, on the 5th of March, HR reached out to him and again reminded him that this was mandatory training for all employees and asked him if he had any barriers to completing the training. Only then did he raise his complaint about John Waldron's email and the training itself. But the record reflects that Honeywell never stopped trying to get him to take this training. Even after he made his complaints, he continued to receive the daily automated emails. Mr. Maines met with him. And then when they met with him on the day of his termination, before he went into the meeting, Jeff Cortez, his direct manager, asked him if he was sure that he wasn't going to take the training. And in that meeting, he was explicitly given the option to take the training and was told that if he would not take the training, that he would be terminated. Mr. Vabra understood the seriousness of that because he left the Zoom, said he needed to speak with his wife, came back, said he was not going to take the training, and indeed he was told he was being terminated because he did not take the training.
It seems from the record that he was otherwise a good employee. Is that a fair statement?
I think that is a fair statement.
Yeah, in fact, it seems to me that they were urging him to take it and stay with the firm, stay with the company.
I think that's a fair interpretation, that they wanted him to take it. It was required of all their employees. They wanted him to take it. They wanted to keep him employed in that regard. But he continued his refusal. If I could address the argument with respect to his refusal to take the training itself being protected activity, as the court noted, it's not just a subjective belief that's needed, it's an objectively reasonable belief that is needed. And here, he did not have that objective, reasonable belief. He simply couldn't have. First, when you look at the record, as you noted, he did not take the training, but even when the training was announced in November of 2020, That training stated that it was being launched as part of the company's commitment to diversity and inclusion. It stated, quote, "While it's human nature to have biases, we must strive to overcome them to create an environment that values everyone's perspectives," close quote. No reasonable person could have read that missive and determined that, as Mr. Vabra did, that John Waldron's email combined with the training was going to vilify an entire class of people, being white people. And when his continued refusal after he complained, that could not be objectively reasonable once he spoke to his manager, Jeff Cortez. Again, Mr. Cortez spoke with him and said, "I've taken the training. I don't think it is racist." And it includes a scenario where a white man was the victim of unconscious bias and that the holder believed a woman was more appropriate for the position. Once he had that information, he could no longer objectively believe that the training was meant to vilify an entire class of people. If there are no further questions from the panel, I would ask that the panel affirm the decision of the district court.
Very well. Ms. Colvin, Mr. Beck?
Thank you, Your Honor. Two very quick points. First, about the warning about termination. The first mention of it was on March 19th of 2021. The termination decision was made 6 days after that when the Zoom meeting was scheduled. This was the day after he made the official report, said consider this official report. With regard to the objective belief about the discriminatory nature of the training, we need to look at the time that Mr. Vabra made his decision. Again, because under the Mygar case, we don't go back and try the case and say, hey, you know, as it turns out, it's not discriminatory. What he knew at the time was based on John Waldron's extensive email and the implicit bias aspects of the training itself, which go far beyond simple legal compliance. So we would ask that the case be reversed and remanded back to the district court. Thank you.
Okay, very well. Mr. Beck, thanks to you and your colleague. Ms. Colvin, thanks to you and your colleagues. We'll take the appeal under advisement, and that concludes today's arguments.